what is your name?
Judge, his audio is, I've been messaging him for the last 15 minutes. His audio is not connected.
I don't know what to tell him.
The only thing we do have Joseph Scotty on the 8:30 call for a pretrial, and that's the only unrepresented party I had that's a male.
You have the rest of the motion with some. I need it. Just take them right here. Yeah, I got it. Get him. Wait for him again. Capital reach. Thank you. Cavalry SPV 1 is assignee of Citibank versus Brittany McKenzie, 2303187 GC. Good morning. Do I have somebody here for the plaintiff?
Your Honor, I don't think I've had anyone check in on that one for the plaintiff.
Shocking.
Your Honor, who's the plaintiff's counsel representing Citibank?
Brittany Law.
Okay.
I mean, it's just shocking. Ms. McKenzie here?
No, Your Honor.
Past that case, I don't know.
We mailed out
Synchrony
notice
Bank,
on the 7th.
Synchrony Bank versus Virginia L. Clemens, 2502214.
Good morning, Your Honor. Jay Begg, P36820 on behalf of plaintiff.
Yes, good morning, Your Honor. John Filkins, P70263, appearing here on behalf of Virginia Clemens.
Okay. All right, so today is the date scheduled for, I believe, a pretrial. I need a pretrial loaded. And you guys haven't resolved this under any circumstance, correct?
It has been resolved. We're just trying to locate the settlement check that defense counsel mailed. If we could just adjourn the pretrial, maybe a couple of weeks or so, I'm sure we'll find it and file a dismissal.
I need a pretrial order. All right. Well, what is the terms of the settlement? Why don't we
Sure.
put the terms of the settlement on?
Absolutely.
Okay, go ahead.
Yeah, so John Filkins here on behalf of the defendant. The terms of the settlement are a one-time payment of $1,200 to be paid in one lump sum. That satisfies the entire debt with a judgment entry of dismissal to go on. I would advise the court on September 30th of 2025, I sent a cashier's check for the sum of $1,200 to Roush Sturm at 300 North Executive Drive, Suite 200, Brookfield, Wisconsin, 53005. I corresponded with plaintiff's counsel, provided them a copy of the cashier's check for $1,200. We followed their instructions with regards to placing the file number onto the check. And the last communication I had was, we have not received your check. So I've gone to the post office and they can't put a trace on it because it was sent by regular mail. So that's a good summary of the settlement, and what we're waiting on is, for whatever reason, they're not able to locate the check. I will tell the court that I had my client contact her bank. Because it's a cashier's check, she cannot cancel that check until 90 days has expired. So it's not a simple matter of just reissuing a new check. She has to wait for this one to either clear or be canceled.
And you guys were going to then do a stip in order to dismiss with prejudice, correct?
Yes, I've already prepared that. I've already provided that to plaintiff's counsel. And so we're all set to conclude this matter. They just have to get the check.
Well, that's surprising though. They don't have it in 3 weeks. You're talking about 20 days.
Agreed.
I'm gonna adjourn it 2 weeks. Okay, gentlemen, we'll see you here. Give me a new date.
Wondering if that's.
I can hear the audio.
Okay.
Yeah, and then, Your Honor, it's I think the mix-up is because the wrong file number was put on the correspondence, but the terms were $1,200 to be paid by August 28th, 2025, and that would satisfy the
Wait a minute, you cut out. Listen, Jennifer, I need another date in 2 weeks. What's that? The 3rd
November 3rd.
at
We'll do 8:30.
8:30. So you're saying you're not going to raise the issue of him not tendering the payment timely, correct? You said it was supposed to be sent by August 25th, and he's telling me he sent it on September 30. Mr. Bay?
Well, Your Honor, the settlement agreement that Brother Counsel emailed me maybe about 15, 20 minutes ago indicates the payment arrangement, $1,200 in one payment, due date August 28th of 2025. I'm just reciting what's on the settlement agreement and
Just asking if you're gonna raise that issue. I mean, if I Mr. Stokens, why didn't you guys send it on August 28th?
Well, a couple of things, just so that the court is aware. Number one, we had originally arranged for payment to be made by wire transfer. I had provided the information, the bank number, routing number, etc. They put out the order for the transfer of the funds. My client then was notified by her bank that this is a savings account. We cannot issue electronic transfer from.
You know, things have gotten so much more complicated since I was a lawyer. You know that?
Yeah, so it wasn't a matter. Yeah,
I'm
so
just asking you, Mr. Begg, if the check shows up, you're not gonna raise that as an issue, correct?
I don't think so, Your Honor. I think as long as we get the payment. So
Well, I'm gonna hold you to it. I don't want you coming back in 2 weeks, you know, and say, I thought about it and I'm gonna raise that. I mean, you're not gonna do that, right?
yeah, I'm not gonna do that. If the funds are with over at plaintiff counsel's office and just need to be found. But
I
if
know.
they've
Okay,
been
here's
sent-
what I'm
yeah,
doing. I'm
it's
adjourning it
fine.
until November 3rd at 8:30. But I want to tell you, I'm not going to be adjourning this just so everybody knows. So you need to utilize your best efforts to find out where the cashier's check is. I can't adjourn it for 90 days. So I hope nobody's going to come and ask me to adjourn it until January. I just am not going to do that. Okay, so you're going to have to figure something out. If the cashier's check is not cashed, then your client's going to have the funds reissued to her, correct? After 90 days.
yes, correct.
So I'm going to suggest that you get $1,200 more. You guys figure out a more organized way to take care of this if there's such a thing. And then we can go ahead and, Mr. Begg, you're shaking your head. Tell me.
No, just not for any reason, Your Honor. If the funds show up, plaintiff's counsel is not going to raise an issue about it, okay? It's only fair.
No, I get it, but I'm concerned that it's not going to go through. We'll cross that bridge when we come to it. I'll see you guys
Yeah.
in a couple of weeks, November 3rd at 8:30. Thank you very much.
Thank you.
Thank you, and I do have one more at 9 o'clock, Havenwick Hospital versus Wardell. Just to let you
Okay.
know.
I'm going to call these 8:30s first, so get that one ready, will you? Bank of America versus Kim M. Harris at 2502338.
Good morning, Your Honor. Cezanne Barnaby, 65425 on behalf of Bank of America.
Good morning.
Good
Your Honor.
morning.
Jocelyn Uy, P64890 on behalf of defendant.
Can you do me a favor, counsel? Can you turn your volume up there a little bit? This is what happens when you get old. And your P number again is what?
64890.
All right. All right,
Honor,
no
John-
resolution. We're just gonna set dates. Is that right, Mr. Barta?
That's correct. Jocelyn and I have many files together. It will get resolved. We just need some time.
Okay, tell me, what do you guys want? What's today, the 20th? All right, how about if we do this? No ADR discovery until December 20th. Nobody demanded a jury, correct?
Correct.
That's right.
I'm gonna put down 1/2 hour for trial. You're gonna give me the time, Jen. Momentarily. We're gonna have witness list due by November the 20th at 25. You don't have to file a trial brief. If you choose to file it, it has to be filed and exchanged not later than 7 days before the trial date. And that is, let me see here. I'll give you, give me a date for a trial, Jen. I'm thinking in 26, like the latter part.
Judge, we would go to February 10th. We've got an all-day trial on your last civil day in January. At 10:30.
What case is that?
Oh, I'd have to look it up. Oh, I think
Go
that's Concord and Mount.
No, that's gonna go. Okay, give me an
Yeah.
early February date
February 10th at 10:30.
at 10:30. Okay, February 10th at 10:30. Anything else, Mr. Barta?
No, sir.
Anything else, Ms. Uli?
No, sir.
I hope I'm pronouncing that correctly.
Yes, Your Honor.
Okay, thank you. Thanks.
Thank
Have a
you.
good day.
Bye-bye.
You have another one, Mr. Barta?
I do. Bank of America versus Strauss.
Hold down the there. We need another. Bank of America versus Stephen Strauss. I need another one. 2502940.
Good morning, Your Honor. Cezanne Barta, P65425 on behalf of the plaintiff.
And good morning, Your Honor. Brian Garmo, P71007 on behalf of the defendant, Stephen Strauss.
All right, good morning.
Your Honor, I think we need the exact same dates you just gave for the last case with the trial date on February 10th, 2025 at 10:30.
Good enough. Mr. Bart Garmo, what's your P number, sir?
Sure, it's 71007.
Okay,
And I agree with Mr. Barta. That would work perfect. And I anticipate us having this matter resolved before then.
okay. Well, that's always good news. All right, here's what I'll do. Same thing. We're gonna have discovery cutoff December 20th. We're gonna have witness list due November 20th. Again, nobody demanded a jury, correct?
Correct.
Correct.
Trial date will be 2/10/26 at what time did you tell me again, Jennifer?
10:30.
I'm sorry, 10:30?
Correct.
All right, and put down 1/2 hour. And that's it. No mediation, no ADR. You don't have to file a trial brief. If you choose to file one, it has to be filed and exchanged not later than 7 days before the trial date, okay?
Perfect.
Anything
Thank you, Your
else,
Honor.
gentlemen?
That's all.
That's it?
Have a good day. Do you have any
Thank you.
more, Mr. Barta?
No, sir.
Have a good day. Thank you.
Too.
All right. Do I have anybody here on Cavalry SPV versus Brittany McKenzie?
Judge, I've had neither side check in or call. It
You
was
sent it out
an
what
objection
day?
to Garn.
I know, I read it. Is this not the same lawyer that I've had problems with not showing up before, though?
That I don't. Let me see.
Zeal Credit Union versus Joseph Scotty, 2502433.
Judge, that was Mr. Scotty that was having problems with getting his audio connected. He is in a conference or breakout room right now with the attorney.
Okay, I'll pass that. JP Morgan versus Colin Snyder, 2502676.
Morning, Your Honor. Preston Nate, P77884, appearing for JP Morgan.
Good morning, Your Honor. Gary Apps appearing on behalf of Mr. Snyder. Sorry, my cell phone wasn't working.
You're here for Ms. Law?
Yes, subbing for the purposes of today's MSD, and my instructions say they're not going to oppose it, so you don't have to take very long to wrap this up as far as I'm concerned.
Counsel, would you like to proceed with your motion?
We would like to proceed with our motion, Your Honor. It's just a motion for summary, pretty straightforward, just asking the court to grant judgment in the amount paid for in the complaint of $10,010.36. There would be no court costs, so that would be the total judgment. But we would like to move forward with that.
And no response, Mr. Apps?
My instructions say not to oppose it, sir.
I got it. I just wanted to double check. Plaintiff's motion for summary disposition is granted. There's no genuine issue as to any material fact. 2.116C10 judgment centered, no cost, $10,010.36. You can go ahead and submit your judgment on that, counsel.
Very good, Your Honor. We'll do that. Thank you.
Yep.
Is there anything
Yeah,
else that you have, Mr. Apps? I had another one here with Ms. Law. I don't know where she is.
I go through a third-party employment thing. I've sometimes subbed for Brittany, but I don't have another assignment today. If you want me, okay, is it an MSD? What is it?
This one was an objection to wage garnishment.
Yeah, not that I couldn't have covered that. I don't recall receiving anything like that, so I don't think
Good
that
enough.
I was assigned.
Good enough. Thank you.
Good enough, sir. Thank you. Good week.
You too. Havenwick versus Kara Wardell in the Garnishy defendant St. Philip Lutheran Church, 2401567.
Good morning, Jay Bag, P6820 on behalf.
Wait a minute, I'm kind of losing whoever is here. Who's entering the appearance?
J Bag, BAIG, P36820 on behalf of plaintiff.
All right, this is for failure to file a garnishment disclosure.
That's correct.
Okay, how did you, I want to make sure service was perfected.
Okay, on April 21st, 2025, the garnishee defendant was served with a writ of garnishment. On June 5th of 2025, garnishee defendant was served with a notice of failure to respond to the writ. On July 7th of 2025, garnishee defendant was served with a notice of default entry. And then on September 11th of 2025, garnishee defendant was filed with a notice of the judgment.
All right, give me 1 second here, please. I guess, I think that nobody responded to this. And I was concerned about, I don't know if St. Philip, if that's a nonprofit corporation or what it is. But I need proof that the writ was served on them in accordance with the court rules, which I think is going to be under 2.105D, assuming it to be a nonprofit corporation. I see that there was something mailed to the payroll and human resources. Wait a minute. What I'm looking for is the proof of service of the writ.
The writ
Yeah,
itself, yeah, let's see.
Jennifer, do we have the proof of service of the writ?
Judge, I printed everything in that packet. It should be towards the back if it's in there.
And I'm looking at a proof of service at this moment, Your Honor.
Okay, what does it say?
A proof of service periodic garnishment is an affidavit of service. Let's see, it's on the scale form. The proof of service, it has the affidavit, certified mail receipt, garnishee name, St. Philip Lutheran Church, attention payroll / human resources, date, the address date, April 21st of 2025, service fee,
21st of 2025. I tell you, I'm gonna, this is just, I got everything but that. The way it looks to me.
yeah, and then I have the US
What do you
Postal,
have? What's it show that you was served?
I have a copy from the post office that indicates a signature of recipient, of the recipient, and the
Who's the
address of
recipient?
the I can't read the signature, but it's a signature.
Well, I know, but you can't. You either have to serve it on the officer or resident agent or the director, trustee, or person in charge, and by registered mail, but addressed to the principal office. If you have that, send it over. If you don't, we're going to have to start over.
Okay, very, very good, Your Honor. I don't see,
You know,
at least in my
I don't know
file.
why this is the most. Is it? I've asked lawyers this before. Why this happens, because it's the most ignored rule in the Michigan court rules, the writs of garnishment. I find that they're served improperly the great majority of the time. The only explanation I got years ago was, well, we don't want to have to spend money to send a processor type thing. I'm not saying it from you or your office. But then they send me these judgments and I don't feel comfortable. So I'm going to, barring anything else, plaintiff's motion for entry of judgment versus garnishee defendant is denied. If you have something else or you want to reserve and take care of it that way, I will do that. Kind of seems strange that a church would ignore this even if it was properly served. So I don't know, maybe you want to call them first, do whatever you want to do, but.
No, I understand, because it's, and it has to do with even the regular service rules on a corporate entity.
Right.
So, yeah.
Sorry, Mr. Begg.
No problem.
Have a good
Thank you,
day.
Judge.
Thank you.
You too. Thank you.
Are we ready on Zeal and Scotty?
Yes, we are, Your Honor.
Okay, Zeal Credit Union versus Joseph Scotty. This is file number 2502433. Mr. Scotty, can I have your name, please?
Yeah, Joseph Scotty.
And counsel, your appearance?
Clarence Kennedy, P88082 on behalf of plaintiff.
All right. 88082.
That's right.
When was that passed?
This is just last year, just last December.
So you've been a lawyer for roughly, what, the July bar or the?
July bar, yes, Your Honor. So just about a year.
We're about ready to hit 90s then, I think, right? All right.
I think so,
Anyway,
sir.
did you guys talk and try to resolve this?
Yes, Your Honor. So Mr. Scotty and I, and then my client had a previous arrangement pre-suit. And, you know, we're looking at reducing the amount owed per month on that arrangement before memorializing it into consent judgment. So just a standard scheduling order would give us enough time. I just got to get approval from my client to reduce the amount owed on the balance in full, and we should file that with court.
No problem. Give me 1 second here. Yeah, we're gonna do the same thing on this one. December 20 discovery cutoff. Nobody demanded a jury. True, counsel?
That's right.
November 20 will be the November 20 of 25 will be witness list due. You don't have to file a trial brief if you choose to file one. You have to file and exchange it not later than 7 days before the trial. I'm going to put down February 10th of 26 at 8:30. February 10th of 26 at 8:30. Mr. Scotty, I'm going to send this out to you.
Yes, sir.
The pretrial order. It's going to take us a few days, but it's
Sure.
going to cover everything. I'm going to encourage you to read that very carefully, okay?
I will. I will.
I mean, if they
Thank
have
you.
something you want, discovery's the exchange of information, you can make a written request for that. And we'll go from there, okay?
Okay.
Thank you very much. Have a good
Thank you,
day.
Your Honor.
Thank you, Your Honor.
Thanks, counsel.
I do have one other matter in front of you today.
What time's that scheduled?
That was scheduled for 9.
Tabitha here.
And opposing counsel is here.
What case is that?
It's Credit Union 1 v. James Paulson. And Mr.
Credit
Paulson
Union 1
represented-
versus James Paulson. I believe, 2503126. Need a pretrial. Oh, I got one. Okay, Mr. Kennedy, your appearance.
Clarence Kennedy, P88082, on behalf of plaintiff.
Good morning, Mr. Sayeg, your appearance.
Hi, good morning, Your Honor. James Syed, P80407, on behalf of the defendant, James Paulson.
A little chilly out there this morning, isn't it? I think we're headed for not so great weather again, but whatever, we'll get through it, right? All right. Okay, so I've got, give me 1 second. I'm just filling out these pretrial orders. Credit Union versus Paulson. All right. Any resolution or you want dates?
Dates, Your Honor. We haven't reached a resolution yet.
All right. Nobody demanded a jury, true?
Correct.
That's correct.
November 20 will be witness list cutoff. You have to file your witness list by then. There's not going to be a settlement conference since it's a bench trial. You don't have to file a trial brief. If you choose to file it, it has to be filed and exchanged not later than 7 days before the trial date. December 20 will be discovery cutoff. November 20 will be witness list due dates. I'm going to put down 1/2 hour for trial. And that's going to be on February the 10th of 26 at 10:30 in the morning. Okay? Anything else, guys?
Nothing further for plaintiff, Your Honor.
Nothing further for defendant. Thank you, Your Honor.
Have a great day. Thank you.
You as well. You also.
Okay, what else do I have here? Velocity Investments. Are these guys online on this felony? Or this?
What even was out there?
Okay, just tell them I'm going to come on right after this. Velocity Investments versus Brian Griffin. File number 2502701.
Good morning, Your Honor. Robert Fikens, on behalf of Brian Griffin.
How you doing, Mr. Fikens?
I'm doing well, Your Honor. How are you doing?
Do you remember me?
I do remember you.
I only clerked for that firm. What was that? 42 years ago.
Yeah, I think so.
Crazy.
I think you're
Nice
right.
to see. Nice to
Good to
see
see
you.
you. Good to
Who's
see
here
you.
for for Velocity Investments? Anybody here?
No, Your Honor, I'm not having anyone check in. I'm looking right now.
Can you call him? It's Stillman's office.
Yes, I will.
Thank you, Judge.
Just bear with me, Mr. Fikens. I'll be right back with you, okay? Nice to see you.
It's
Good to
always
see, good to
And
see you.
I'm sorry.
Judge, Mr. Fikens, I don't have his appearance on this case yet.
I'll
If
Did
they
you-
can send it through M-File.
I'll do that.
Yeah, you can do that while we're getting Mr. Stillman here. How's that? Thanks.
And Mr.
Okay.
Scotty, you're free to go.
Thank you, I appreciate that.
You're all
You're
set, Mr. Scotty. Have a good day.
You also,
Okay.
thank you, sir.
After 42 years, Judge, I still don't know how to do the M-filing, but I'll try to get it.
Listen, I would like to not have that. It's, we're old school guys, right?
Yes,
I
sir.
mean, it's just, it makes it a lot harder for me, a lot harder more importantly, for the staff. All right, where is,
I called them again, Your Honor. They were out there, they disappeared. Mr. Haynes is ready to go. I called them again.
okay, I'm gonna just wait for that one, Durwood, if you can just bear with me, okay? 501729. Your name, ma'am?
Good morning. My name is Irina St. John.
And Mr. Schwab, your appearance? Mr. Schwab? All right, Mr. Schwab, your appearance? You're still muted. Now you're not.
Thank you. Paul J. Schwab, improper.
I have two motions in front of me, as far as I can tell. There's been all kinds of things filed in the last 2 days.
You are correct, Your Honor.
Oh, ma'am, I cannot hear those. You have to give proper notice to the other side, okay? And we have to schedule those. You can't just file them a day. I was told you filed something on the 17th late in the afternoon, which was Friday. And then,
I'm sorry, Your Honor, Mr. Schwab filed renewal of request for sanction on a 17
okay,
that I received, and I was working all these 2 days, so I couldn't respond. I responded yesterday, but I understand that you probably don't have this in front of you.
I don't, because they haven't printed it out. So I don't know what you filed. You certainly can file a reply, especially if he filed something else. But I'm going to focus on two things here.
Okay.
I'm going to focus on the motion to strike the witness Julia Belova, and also the motion for sanctions and frivolous pleadings that he filed. So you can go ahead and proceed, Mr. Schwab, with your motion to strike the witness Julia Belova first.
Thank you, Your Honor. The motion is straightforward. I represented Yulia Belova 20 plus years ago, I believe in 2005, 2004. It was a divorce. Again, it just unbelievably, but it was a divorce. What I did 20 years ago has no relevance to the issue before the court. The only issue before the court today is the breach of contract by Irina St. John. She failed to pay attorney fees. Now, in the trial, as the court knows, I have the burden of proof. I will testify as to the work that I did in the divorce. I will testify as to the charges. I will testify as to the payments that Miss St. John made, and I will testify as to the balance that is unpaid. Miss St. John will have every right to try to discredit me. Julia Belova knows nothing about what went on in this case, knows nothing about the services I rendered, knows nothing about the relationship attorney-client that St. John and I had. It's just, it's hard to oppose. It is irrelevant. It is past conduct to prove present conduct. Relevancy, I cited the court rule. Believe it's 401. Past conduct, I cited the court rule 404. I mean, the rules of evidence. It
All right,
is
okay, let me hear
irrelevant.
from
So
Ms.
that is my argument.
Let me hear from Ms. St. John. Do you have an argument, ma'am?
Yes, first of all, I would like to say that I was following Your Honor order, pretrial order on July 29, 2025, where you said that parties shall exchange and file with the court names of all witnesses to be called to the trial, no later than October 1st, 2025. So I filed my witness, Julia Belova, and I filed a response for Mr. Schwab's citing MRE 401, 402, and 404, where he states that I cannot use Julia Belova to prove present conduct with a past conduct. And I know that, and this is not what I'm saying. I'm saying that Rule 404B Part 2 permits users, and the rule allows admission of Ms. Belova affidavit and testimony as a witness to show a scheme, plan, or system of doing an act. This rule states that if it is material, the evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation. In my case, it's a scheme, plan, or system of doing an act. The witness can be admissible. Julia Belova's affidavit and testimony would be a material to show the consistent patterns that Mr. Schwab does. He overbilling his clients, then he files frivolous lawsuits against unpaid legal fees, and then he files and requests sanctions against them. This is what he did to Julia Belova. This is what he does to me. So that's why in my case, I using my witness to prove the scheme, plan, or system of doing this act.
Okay. So I want you to know, I read these motions. I read the motion, and I want you to know I'm gonna grant his motion to strike the witness. And I'm going to grant the motion because under 401, because it's simply not relevant evidence as to what happened with some other client on some other case 20 some years ago. That is my ruling. And honestly, even if somehow, some way, I'm going to read you 403, although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. It's the same thing here. Again, I don't think it's relevant at all. And if somehow, some way it is relevant, a case that he handled with totally different facts, totally different circumstances, particularly one that's over 20 years old, if it somehow is relevant, the probative, ma'am, let me finish. The probative value is substantially outweighed by the danger of unfair prejudice. So I'm going to strike the witness for that reason. I'm going to ask you to prepare an order. Now, the bigger issue here to me is the motion for sanctions. Mr. Schwab, I tend to agree with her. I had an outrageous, frivolous claim filed against lawyers not long ago, maybe a year and a half ago. And I asked the lawyers when they sought sanctions, I said, you're going to have to provide me with proof that a pro se lawyer, a lawyer representing himself or herself, is entitled to sanctions. And she cited plenty of law, and I don't think you are. If you want to brief it, I'll let you brief it more in depth, but I don't see how you're entitled to sanctions when you're representing yourself. So if you want to take that into account and and make your argument now, I will listen, but that's my inclination.
Your Honor, I am engaged full-time in the practice of law. I have presently probably 200 or 300 active clients.
You're working too hard.
I know I am. I know I am. If you know a young attorney who would like to take over a practice, I'm available. But back to the argument.
I didn't write the
All of this
laws,
time,
but I suspected that was the law. I told them to brief it. They declined, and she's provided me with enough.
all
I
right,
mean,
I
if
will
you've got
drop.
a case that says, if you've got a case that says a lawyer representing himself or herself is entitled to sanctions, I'll invite you to provide it to me and I'll adjourn this for a week, but I don't think such a law exists.
Your Honor, I'll dismiss the motion for sanctions
All right.
so that we can move forward.
On his motion for sanctions, that is, so let me just make a note here. Motion to strike witness Belova granted.
Your Honor, can I just say one thing?
Sure. Unless
I'm
you're
not
going to argue with me. You're not going to
No,
argue
I
with me
will
about my
not
ruling on
argue
the
with
other
you.
case, are you?
No, I will not argue with you. I just want, I'm not arguing with your decision. I just had no opportunity to add with Julia Belova that she was not only one case
Ma'am,
that could
I'm
prove that.
I'm sorry that you named a witness. He's asked me to strike. It was over 20 years ago. He was practically a kid then. So come on. This is not a difficult call with all due respect. It's
No,
not a
I'm
difficult.
I'm not arguing with you. I was just saying that I submitted also 13 other cases that he did the same 13 cases
And I
within
gotta
last.
tell you, if you bring those witnesses in and I hear what you just told me about in so many words about Belova, I'm not gonna let them testify. It's not
Okay.
relevant, okay? I
Okay,
mean,
thank
so
you.
you can feel free to bring them in. And if it goes down that route, I'm just gonna be telling you, this is not relevant. To the extent that it is, the probative value is outweighed by the danger of unfair prejudice. We're not gonna relitigate what happened 20 some years ago or 2 years ago even, okay?
Okay.
And then motion for sanctions dismissed, withdrawn by counsel.
Your Honor,
Okay.
one other
Now-
request. If the court would explain to Miss St. John that's improper to list the home address of the party.
Yeah, I don't know why you did that, ma'am. Don't do that, please. Please. You list his business address from now on your pleadings, okay? Not your not his home address, all right?
Oh, Your Honor, I didn't do this intentionally. All my court notice to appear and all the court documents that I received, they contained his residential address. And Mr. Schwab didn't file the motion to seal his address and not to use it as a court.
Hear me out a second. Your business address is what, on Greenfield, Counsel?
Yes, Your Honor.
That's what I want you to copy in all further pleadings. 30075 Greenfield Road, Suite 110 in Southfield, 48076, okay? Ms.
Okay.
St. John?
Yes.
When do we have a trial date on this?
November the 17th.
And you guys don't think it can be resolved, huh?
Not with Miss St. John's mindset. No.
Okay. All right. Okay. Is there anything else that I need to address right now?
No, Your Honor.
Ma'am, anything on your end you think I need to address?
Mr. Schwab doesn't want to cooperate, so I guess.
Hang on a second. Who's talking to you back there? Who is that?
I'm sorry.
Who was that talking to you back there?
That's my family friend.
Well, tell your family friend to come into the camera. I want to talk to him. Sir,
morning,
what is your name?
My name is Leon Kaiser.
Okay, so listen, if I were in court and we were in open court and she was in front of me and Mr. Schwab was in front of me, you couldn't come up and talk to her then. So please don't do that again. We're probably going to have other hearings on this, okay? So you can't talk to her when I'm addressing her and we've got an open court hearing, okay? Do you understand what I'm telling you?
I understand that if necessary, Your Honor, I can appear in court as well.
Well, you do what you want. If she's listed you as a witness, she's welcome to call you as a witness, but you're not going to come up next to her on by the podium and start telling her what to say. That's all I'm telling you
Of course
nicely.
not. Of course
Okay.
not.
All right, good enough. I think we've got that all set and we'll have the trial momentarily. And we'll go from there. Thank you very much. I'd encourage you to keep talking, but
Thank you.
if you don't think it's possible to resolve it, I get it. Have a good day.
Thank you, Your Honor. I'll submit the order.
Thank you
Thank
very
you.
much.
Thank you.
Okay. Let's do people against Owens, Marlon Amir Owens, 25B149007.
Ready, Robert. Sure would ask of Marlon Owens, is there a warrant that needs to be recalled here?
It's already been recalled. Where were you?
Out of town for work,
Your name?
Marlon Owens.
Did you bother calling anybody?
Well, I did, but it was the day after, because I called before it shut.
You can't do this. You can't do this. You just can't do this. Why would you not call before? Why would you not have told me when I set the sentencing date for October 16th, Judge, I gotta work? Why would you not have told me before you went out of town, Judge, I've gotta work?
Well, because I asked the clerk before, could I get a Zoom interview, and they wouldn't let me do it.
Mr. Owens, you're not gonna force me to talk about other things, are you? Because here's a fact. I told you to show up, should have been here the 16th. If work made it impossible for you to show up, you should have told us on the date of the sentence date. When I set the sentence date. And if you didn't know then, the moment you found out, you should call and said, I need an adjournment. Don't just walk in here 4 days later. I got to read this report again. I don't remember. I don't think the victim showed up, but they might have. Wait a minute. Oh, yeah, the victim showed up. Oh, yeah, the victim showed up. I remember this one now. If you pull this nonsense with me again, bring a lot of cash with you because I'm going to set a high bond, okay? You had a victim here that showed up. I was here. Ms. Patillo was here. I read the report. She read the report. You're not going to inconvenience people. If you're that rude in real life, that's your problem. You're not doing it in here. Are you with me?
Yes.
This was an ugly one, too. Ugly. Ugly. Let's set another date when it's convenient for Mr. Owens. I have a good mind to forfeit your bond and send you to jail right now. You know that? I have a good mind to take the, I mean, I just do. I have a good mind to set a high bond right now. You play this nonsense with me. I got called out of town for work. I don't get it. You might as well bring in a banner that says, I have no respect for the judicial system. Not for me. Forget me. I'm just a pawn here. I'll sit here as long as they let me, but can't be doing this. Do I have a date? We're going to have to set it for November the 5th at 8:30. John?
Yes, sir.
Mr. Haynes, will you do me a favor? There's somebody, just take this down. We got it. The victim was here last time. Make sure victim notified. Is that convenient with you? I don't want to inconvenience you in any way, Mr. Owens. You sure? Okay, I mean, you don't want to do it on your boat or something next summer?
Judge, look, how you pointed on this?
Yes, Ms. Patillo. And she's still gonna be on.
Will she be here that day or do we?
I assume that's the day that they gave me in. Okay? Thanks a lot. Don't do it again. Good luck.
Did you want me to lock that file down?
I'll take it.
One of you guys, who cares? Yeah, it doesn't matter to me. Thanks. Ryan Griffin. All right, so in the Brian Griffin case, is that 10:30, Jennifer?
Flat right here.
Come forward, sir. As we begin here today, you are Darmine Wilson Jr., present with your attorney, Mr. Eckert, and the state's attorney in cause number 23-41506. I understand the defendant is going to be entering a plea today to this indictment. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in summary?
We do, Judge.
In summary, this indictment alleges, sir, that on or about May 8th, 2022 in Jefferson County, Texas, you committed a second-degree felony of aggravated assault with the use of a deadly weapon, namely a firearm, by shooting the complainant. Do you understand what you're charged with here? If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement has been reached where you would be pleading guilty, sentenced to 12 years in prison. Is that your understanding of the agreement? Yes, sir. If I follow this, you have no right of appeal of your case. Do you understand? Yes, sir. How do you plead to this indictment, sir? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. I show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily? Understand it. Discuss it with your attorney. Are the contents all true and correct? State's Exhibit 1 tendered into evidence and without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, or you've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the defense, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true at state, so help you God. State's Exhibit 1 then is made a part of the record for all purposes. Pre-sentence report is waived. So if nothing further to add, I will follow this agreement you all have reached. I'm going to find then that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this second degree felony of aggravated assault as indicted here. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 12 years. And the judgment shall reflect an affirmative finding that a deadly weapon was used in the commission of this offense, namely a firearm. Do you understand? And you would be given credit for all time you have spent in accordance with this case. Do you understand what's happened today, sir? So anything else to add by defense or state? No, sir. All right, we are in recess. Thank you. Still not always. This is still listed. And thank you, ma'am. Mr. Kelly, I'll give you all two Pam. Y'all are ready, right? Is that right?
We are ready to try the case, Your Honor, but Mr. Ham.
Mr. Ham, Is what?
Yes, Mr. Hand made an offer to us that I have been discussing with my client.
Okay, what can just, where's it?
She's outside.
Oh,
Just
tell me what's gonna happen.
I've got a judge. My only other issue,
It was it was up at the top here.
I understand, my only other issue, Your Honors, I've got a hearing in Judge Stetson's court this afternoon. So if we are your number one, I'd ask that we come back tomorrow if we can, but
What is it?
it's a quick enough case, we can do that. And he advised me about the conflict. I can work around that.
About what?
He advised me about his conflict. I can work around that.
Just let me know one way or the other.
I just need a minute.
You got five.
Thanks, Judge. 6, please.
Did John? There you are.
Okay.
I got a list of stuff for you. Travis Jacks.
Hold on for that. I think I was about to talk to you for the first one, at the very top first.
Yeah, I just thought the one to trying to confuse you was a good strategy.
Different, yeah. Let me hold on Travis Jackson. I'll give you an answer in a second on that one.
What about Terry Prudhomme?
The state just talked to me. I talked to my client again for a new offer. That should resolve it, I believe.
Okay, let's do it.
I'm gonna do it right now. That's what I was
Okay. Ordell May.
ready for that one if we have to go.
Evading arrest. Okay.
Yeah.
All right.
We talked about that several times.
That one's a brief case.
Yeah, it's short.
It's a good one, Judge.
Okay. Mage McMillan.
Mr. McNally is right there. And
Where's Mr. McMillan?
right.
Raise your hand, sir.
There you go. Okay. Yeah, ready on that one, right?
He also has Hernandez.
It's also got the oldest case.
Yeah, I know. I was going. I know. I wanted to get the other stuff signed.
Yes.
This. Hold on.
Let's try it.
Yeah, I think he's adamant, I'm not a lawyer, that he won't use Miss Jackson, one of the daughters of jail. This is lawyer. So. I'm real. So.
Mhm. Mhm.
Where's Mr. McMillan? Okay.
Mr. McMillan?
Yeah. You you were in jail and then you posted a bond, right? So yeah, okay. What is his bond? What was his bond? I'm curious what we did here.
Okay.
Look at that reset. Look at the top. This bench trial, not a jury trial.
Nobody's.
I wouldn't have done that, but I wouldn't have marked through that. That's not me. Somebody else did. It says bench trial, not jury trial.
The check wrong line?
No, it's just.
Is that what y'all want?
I don't think so. No, it's not.
Well, this is odd. I mean, it's back in March.
I'm not sure what it was. I know there was an issue about his bond. We requested a bond reduction.
Well, yeah, he wrote a letter, but he made a bond.
Yeah.
I'm not sure, Judge. Somebody else worked docket for me that day, so I'm not quite sure what happened.
All that to you.
Well, all right.
But his bond is $75,000.
Okay. Yeah. Who's
That's Mr. Laird.
Mr. Laird's on this one?
Just that happened. That's
Come on up, everybody.
They both made McMillan.
Mr. McMillan, then, I'm looking at this, I'm talking to the lawyers, I'm looking at this case. You understand, don't you, 100% that you cannot have any contact with the complainant victim here? Do you understand that?
Yes, sir.
Okay. And I presume you have not, because it would be catastrophic if you did. Catastrophic. I would pull your bond immediately if I find that out. And you would sit this out in jail until we can try this case. But any contact any defendant has with a victim complainant automatically results in the revocation of their bond, and they don't get a bond. It would be catastrophic. So, and these things happen in this type of case. I've done this long enough. It happens. That's why I try to warn people. So it would be a catastrophic event for you if I find out that you or someone on your behalf attempted to contact the victim. And what we were doing on Hernandez?
Your Honor, tried to pass along the offers to him. He is very uncooperative with me. But I'm ready. I mean, I know the fact of the case, Mr. Ham.
How long do you think that would take? Okay.
Probably 2 days with the
All
jury.
right. We don't need to bring him out or anything.
That's not gonna do anything.
He will put on a show if you do.
Yeah.
I understand.
Yes, sir.
Yeah. Well, it's time for the show to end, huh?
That's fine. And
that's what I've been thinking.
Okay, who else?
Well,
who else is working on something on these?
I'm working on Mr. Prudham. I'm gonna visit with him and see if I can get that resolved.
I'm waiting to hear back from Mr. Kelly on FAM.
Okay, you're working on that stuff is coming around in a few minutes. So, sure. Because I'm gonna let me hold the setting of these cases for a few minutes while these last cases get disposed of. Probably not get. Langston, Adams.
That's right outside, Your Honor.
Thank you. Give me some of these announcements. Thank you.
It was about half the stack.
Half the stack. Yes, sir. Aldrian Jerade Booker, 2 cases.
Yes, sir. And I spoke with him about what he's on. You want to bring him up?
Do I? I don't know.
No. On Booker's case,
what do you? It's an announcement.
It's an announcement, Judge. He is adamant on his case that he wants trial.
All right, it's set for trial.
No
We're going to
problem.
try the unlawful possession of a firearm first, okay?
That's no problem.
All right, when can you be ready on that?
Whenever you tell me.
All right, as soon as 6
But
weeks.
today. If you want to do it today, we can make it out.
6 weeks, is that good? All right,
That's
we
fine.
set it for about give or take the week. Let's move that one and be unlawful possession of a firearm by a felon.
No problem.
And
Judge Chaldron.
Jeremiah Chaldron.
I don't know if you remember him, but he was the guy that had the inadvertent like twitch, I believe. And I think the report had found him as incompetent.
Yes, that's true. Do we need him out?
I don't need
I don't think we do.
I won't need it.
In cause number 23 CR 309, there is a motion to revoke probation that was filed in its case in April of this year. Subsequent to that, the court deemed that the defendant needed to be evaluated for competency based upon reasons that had been articulated to the court by that the court was informed of. So the court ordered Dr. Ed Rapon, licensed psychiatrist, to evaluate the defendant. He has. And we have an evaluation product here dated September 22nd of this year. Listen. Where the defendant has been deemed incompetent by Dr. Griffon. I'm going to call this court's exhibit number 1 on this date. And maybe part of the record for all purposes. In summary, the defendant is diagnosed with having a psychotic disorder.
Yes, sir.
And is incompetent to proceed to a legal resolution of this charge at this time. He is unable to carry on coherent or rational conversations. And his mental state appears to be significantly decompensated, according to the doctor, and would be unable to follow legal proceedings, and will be expected that he can conduct himself properly in a court of law. He is mentally ill and incompetent to stand trial. Involuntary treatment intervention on an inpatient restoration basis for competency is what this doctor has advised. I'm going to follow his advice. Any objection?
No, sir.
And this court's exhibit 1 is made a part of the record for all purposes. The defendant shall be transferred to a mental health facility based upon Dr. Griffon's advice for treatment, with the goal, our hope that he regains competency in the reasonable future. Anything else?
Nothing.
Then it is reset for review at a later time. Thank you.
On my last one was Adrian Williams, Judge. I can convict you on him too.
Okay, Adrian has 3 cases, it looks like. Unlawful possession of firearm by a felon, illegal possession of drugs, illegal possession of drugs a second time. So
I met with him. He had an habitual. Mr. Ham offered the 25-year on his habitual. He's currently on parole, and any deal would violate his parole. Plus, he's saying no to 25 years, Judge. He says no way he's gonna take 25 years.
okay, it doesn't hurt my feelings. That's his
My feelings are a
constitutional
little
right.
hurt, Judge.
Which one do you want to go on? Use
I
the
have so
W.
many to choose from.
I know.
So
Probably do the unlawful possession of the firearm, Judge.
but yeah, he's saying it's.
But that's just a real quick reaction for right now, Judge. But that's something I'll make permanently when it's on the trial.
Okay, on
docket.
January, the other 2, cocaine and methamphetamine possession on or about January 19th. And this other this also occurred on January 19th. Okay.
Yes, sir.
All right. Well,
Appreciate you, Judge.
let's roll this one around quickly.
I got you.
Okay.
Yes, sir.
Thank you.
And Mr. Kelly and I had reached an agreement on food fam.
Is he doing the papers?
Yes, sir.
Tom, you got the papers on 2 Pam? Sir?
Doing it now.
Okay, thanks. Let me know when you're ready.
Yes, sir.
Shannon Ordwan. That's a pro.
Oh, yes, Your Honor. We are filing an ILC petition on her behalf to try and keep this off her record. I think she's an eligible offender. However, regarding the bond in this matter, she informs me that she basically lives in Kentucky and she hadn't been in, this is a 2018 case. She hasn't been in much trouble since then. And so she's requesting the court to consider releasing her today while this ILC petition is pending.
Ms. Tranter?
Your Honor, we would object. She's, by what I can see, she's failed to appear already twice for this court. I think she has a definite flight risk. Can we ask she remain held?
Judge, she'd like to be heard.
Yes, I'd like to say since these charges in 2018 or 19, I moved to Kentucky with my family, and I've been clean ever since then, doing the right thing. I've never got into any trouble. It was just a seatbelt violation is why I'm here, but I do want to take care of all this and just get it behind me. My sister has stage 4 breast cancer, and I've been helping her, and at the time in 2023, I had 2 teenage boys at home, but they've since graduated from high school and got out of the house, so I am, wanting to get this behind me and get back to being a grandmother and get back home.
Do you go by Welch? Is that what you go by?
Yes, Your Honor. Whitley is my married name.
Okay. I just want to know what you want me to refer to you as, Miss Welch or Miss Whitley.
Welch is fine.
All right, Miss Welch, twice you failed to appear. It was a condition of your bond. The main condition of your bond, show up for court, don't get in any other trouble. Twice you failed to appear. Well, I don't understand. This is back in 2023. The case is from 2018. And here we are, now you're saying you're going to go back out of state, which is fine. You can live where you want, but I'm going to deny the request. I'm going to get this case wrapped up. You had you've had 2 years to get this resolved if you really wanted to get it behind you. In fact, looks like we even had back 2 years ago set up a walk-in warrant for you to, if you would have appeared, we'd have recalled the warrant. That's all you had to do. But you ignored it.
I don't have a place.
Yeah, ignoring things rarely makes them go away, which is what I guess the tactic that you chose to go at this case. So I'm going to deny the request. You'll remain in jail without a bond. I've ordered an ILC assessment. Someone will be over to assess you at the jail. That's all.
ILC, and hopefully we can get you out next time.
How long will that be now?
This is case number 22CR 39480, the State of Ohio versus Christopher Moore. Mr. Moore is before the court at the request of his supervising officer to terminate his supervision. Ms. Tranter, anything?
Your Honor, we have nothing. We've had no contact from the victim.
Officer Sukovecki, anything else?
Nothing further than what was indicated in my email, Your Honor.
Okay, Mr. Moore, based upon the recommendation of Officer Sukovecki, the court's going to terminate your supervision at this time. Congratulations.
Thank you, sir.
Good luck to you.
Thank you.
Say, Mr. Ham, I hate to interrupt you on this one, Shannon Ordwine.
Judge, we have, from my understanding, we have some, this is Mr. Arwan's files. We have the redacted copies of the discovery in the back. And I think this is just an update and we should be able to bring them in.
I've given you a bulk of material you're supposed to review to give him today, Judge.
I think we did that, and that's what that is.
Well, no, the discovery's in the back. I can go get it if you'd like me to.
You were going to this, so you called me while you were doing it. Okay.
From my understanding, we have availability to bring them in on Friday while the court is dark, so he can review that.
His investigator is present in the courtroom, and I think you had a standby counsel as well, Judge.
Yeah, John West is the standard.
Where's John?
counsel. I think he's in the back, Judge.
All right, I'll bring him out here in a little bit when John's around.
Okay.
And James Franklin. That would be Ryan Gertz, who's not here. Earl Keelan, Todd LeBlanc. Not here. Bruce Smith, Devontae Gilbert. Devontae Gilbert.
Oh. So that one's in.
Correct. Do you want this for?
For Ryan. Yeah, that would be great. Thank you.
Did you have Devontae Gilbert over there?
Probably.
NTRP, we have a hearing.
No, Your Honor, this is a brand new case. This.
We're gonna get a hearing. Well, it doesn't take long for hearings here.
I
wanted
understand.
4 weeks.
Last month.
I mean, last month. I think last week.
You did. That's okay.
The ages.
That's all right.
Okay, I got it.
They often have it either.
Okay, yeah, this was filed on 9/15. And when are we gonna hear this?
I've requested, I still haven't received my discovery on the basis of the motion to revoke, which is the driving most complicated.
Why not, do you think? It's been 20, it's 5 weeks.
Yeah.
Waiting on the blood test for that, Judge. This came up whenever he had Mr. Baggert as his lawyer. I got in contact with the lab. We found out it's here in Jefferson County. I updated the court as well as Mr. Baggert at that time as to where they were in the process.
Where are they on?
They told me they're going to be, that time they told me it should be about 2 to 3 weeks. They were, their equipment was down. They were recalibrating all that, Judge, and we wanted to make sure it's done right. So even though they have bumped me up in category and priority, I'm not going to rush them from the standpoint of making sure
Okay.
their equipment works.
I mean, we're gonna review it every week until we can get this done.
You know, the other thing is that we are asking for the court to set a bond.
No,
Yes, okay.
no, I reviewed this, no, he's on regular probation.
And I'll work again to get another update, but that's the last update. And I notified that I haven't had a conversation with Mr. Smith about that yet.
About what?
What I just put on the record for everybody.
Okay. Yeah, this is a couple of things. The defendant is on probation for evading arrest and detention with a motor vehicle. And we've got these allegations: operating a motor vehicle while intoxicated with a child under 15. Again, a motor vehicle related offense.
As far as the bond, we would put forth that he has a job here. His family is, I think even though one of the investigators at the DA's office, he's very active as a church.
Well, I know he's got a family. Who was the child under 15 that he was driving? He had while intoxicated.
girlfriend's kid, Judge.
Yeah.
Child. No, no, on this
Yeah, sure.
offense, when we're irresponsibility with a 4,000 pound missile is just not, he was given chances when he was placed on probation, and this is again allegedly irresponsible behavior with a motor vehicle. Again. So what did I say? 2 weeks review?
You said every week, Judge, but I'd love 2 weeks. I think that's gonna be more realistic.
Yeah, I would agree.
Well, let's just set for a hearing on 2 weeks and see where we are.
Yeah, sure.
Okay, y'all just be ready to. Thank you.
Ready to start the hearing, Judge?
Yes. Kendrick Ledet.
Yeah, Charter, that is a case we just need placed on trial docket.
We got 2 cases then. It's 25 CR 461 and 462
Yeah, Charter.
set for trial.
Yes, Charter.
Who's the Mr. Laird alert set for trial?
Yes, sir.
Okay.
I just had another one. Crystal Vaughn, and she refused to come to court today.
Yeah, Charter, that kind of tough problem with her.
Do I have that file?
She should. Crystal Vaughn. Crystal A.O. Vaughn.
You think it's gonna be in that stack on my right? I don't have it in this.
It was right before Schubert.
Mhm.
You heard the word.
Do you have all? Do I have them all?
Yeah. Love we can do that.
We looking for again?
Crystal Bond.
Fine. Right before Schubert went off it.
Not in the stacks.
Can I see that set, Judge? You don't mind.
Yeah.
It's right here, Judge.
Crystal Bond.
Yeah.
I thought y'all said Crystal Bond.
Oh, no. Bond.
All right. I didn't have Crystal Bond.
This client is in serious need of medical examination.
Well, send me something. Did you send me something?
Yeah,
Right.
I filed a motion, actually, except this morning. She even refused to come to court today. They didn't decide not to invite her. Every time I go to the jail to try to visit with her, she falls down on the floor and cries, and apparently that she's having delusions that I'm.
Who's the attorney on this one?
Some
Okay,
kind I'm involved, some kind of conspiracy to have her killed, or
She was placed on probation for evading arrest or detention with a motor vehicle. I don't see anything that we did in that original portion of this case
I have a memory
that had
that we did, but
anything to do with competency. There was.
Yeah, she did. That on the prior case, she was early on. She
Don't talk about this
motion. She was examined by Dr. Capon, was determined to be mentally competent. She has a history of I have her husband here, and she has a long history of mental problems. It's very serious now, and she won't even talk to anybody.
that's. Judge, when Mr. Smith and I handled this, whenever we placed her on deferred back in May, and we discussed all that, and part of the terms of the conditions of probation was supposed to try to help address her mental health situation.
Well, okay, from probation, what was being done? She was placed on probation in May, it looks like.
Yes, sir.
And then right out of the box, failed to report. to the probation office. That's the reason why this motion was filed.
Yes, sir. She never reported, and we tried to contact her, we can't get in contact with her. I didn't see her until she was in the jail.
When you saw her, what did you?
She was she's a little confident when I spoke to her. She wasn't as bad as she is now.
Her situation, in my humble opinion, is aggravated by her drug and alcohol use.
She's been in jail now for a while. I'm sure that probably
I guess it's
does,
from-
contribute
from
to it, but,
June or so, May or June.
Yes, sir.
Darren? What medicine is she taking? Do we know? Yes, she.
I mean, we can't do anything
taking anything.
when we can't get her reported in and dealing with
I understand.
probation.
What
Can't
was she
really help
taking?
her.
Because that was something that we had dealt with before, so. Another thing. So was she on any
In
kind
the underlying case,
of
she,
probation? Was she on any type of
Nothing that we know.
medication?
Nothing that we-
and this was a post PSI, so it doesn't have any of the information that we would need as well to help us, John.
after she was released, Judge, from the jail on this Ocean Grove, she began talking to her husband. She became very, very delusional, and that is why she never reported. Everybody was part of the conspiracy. She was very bad off. And
Okay, I've got something from you called a motion suggesting mental incompetency. You added an order.
I just intended to.
The state would join in that motion, Judge.
Okay, in the body of this, is counsel suggests the court should order an examination of the defendant by a qualified mental health expert to determine competency. That's done. And the court will order Dr. Edgar Pond, licensed psychologist, psychiatrist, to evaluate the defendant.
Yeah, sure.
And that is so ordered. Anything else from probation you need right now?
Thank you, Judge.
Brent, on Mercy. Bruno.
She was not in contact. My mystery about the time.
Guys. Well, it's big, massive incompetency going on here.
Just my office.
Judge, so there's a motion to withdraw from previous counsel and a notice of appearance of new counsel that came in the day after the motion to
Are
withdraw.
you the old or new? New.
Okay, so here's this. So we just need to have,
Mr. Zarate,
Yes, sir.
yeah, and
is there any reason why this should not be granted?
None that I'm
Brandon.
aware. I have met with the client in jail. He has signed
Who was
the
the
contract
previous-
paid.
Motion to withdraw was filed by Mr. Vinus,
Yes,
and then you don't work with Mr. Vinus, do you?
I do not know.
Okay. And well, the defendant can hire anybody he wants, and that's you're representing this court that he wants you
Yes.
to represent him. Okay.
And Judge, we initially reset it because it was our understanding from previous counsel that he needed an interpreter, and we did not have one available today.
What are we gonna do today?
So I was hoping to approach on bond. I just found out that it was reset about 25 minutes ago.
Yeah, the defendant's not here. We can possibly get him here this afternoon, maybe. But we do not have an.
What language is it we're gonna need?
Mandarin. And I have brought my own translator to communicate with him, and if the court also needs to communicate anything with him.
But he's not here.
Mandarin, Judge, that he's facing.
Okay. Well, that's one of the, maybe the leading language spoken on the planet. All right, what do you want just to do today, Mr. Gillard? I'm going to grant this motion to withdraw filed by Mr. Vinus, and he will be allowed to withdraw. And Mr. Zarate is the legal counsel that is now of record.
And I mean, if we could approach later this afternoon or whenever the court has availability.
We won't be able to do this afternoon. It'll be in trial. But what do you want to do? Granted.
Would the court be okay with approaching on bond without the client present?
No.
The shortest reset I can put on my calendar then.
Brandon. Is there an order here I've got to sign that you have? I don't see one. I don't know if it's necessary.
So I do know
your word is good enough for me, you know.
I know opposing counsel filed a motion and order for withdrawal.
I got that
Filed a
signed.
notice of
Now,
appearance.
I want to make sure that the baton is handed off to you. You're in the game right now, correct? That's what you want. That's what you wish. That's what your client wishes. What's the bond on this right now?
10,000.
All right.
And that is one of the things I wanted to approach on his bond and conditions, because he's not a Jefferson County resident. So if he was to release, he would be in or pay bond, he'd be in a very adverse position.
Wouldn't that apply to everybody?
Well, any non-resident of Jefferson County. He is a Las Vegas resident with family, wife, and kids.
Well, he chose to come here and allegedly commit a crime here. So it would be nice for him to commit, if they're going to commit crimes, why don't they commit crime where they live and their residence? But we're here trying to fix all of this somehow with justice. So here's where he was chosen to be when he allegedly committed the crime.
Yeah. So my argument obviously will be just amending that condition so he can come back here for court, but then also be able to leave Jefferson.
Well, his bond's $10,000. That's what it's going to continue to be. If he posts a bond, he must have a GPS device. And so we know where he is at all times. And what is there criminal history here that you state knows?
None that I can find, Judge.
Okay.
And I feel like the bond amount is appropriate. And I was going to ask you to do a GPS device because of this same argument. Your Honor, I'm just affirming that I agree with that. Both counsels that this defendant has had is asked to be able to leave Jefferson County. So,
well, he lives, he has a residence in Las Vegas, right?
Yes.
Still.
I'm assuming that that's accurate, but I sure would like to know where he's at based upon what the condition, what this crime was. And I know you've got the PSC to keep the probable cause, Judge.
Which I have not seen. I haven't seen this case file at all. I just showed up. I mean, my understanding is his bond conditions are GPS monitor, not allowed to leave Jefferson County, $10,000 bond amount, and then the general don't commit new crimes, that stuff.
But I'm okay with lifting the requirement of staying in Jefferson County as long as there's a GPS device. Want to know where he's at?
Okay. No, he can go back to Las Vegas.
Thank you.
If he can post a bond. Yeah.
Thank you.
But got to be here for all court dates. We're gonna set an announcement date for,
Right now, it's on November 10th, Judge.
that's what it's set for right now.
Yes, sir.
But
Soon
this
as
is his
I've got
first
his
appearance. Is that good, or do you need some more time?
Tenth is a perfect day for me, according to my calendar.
Is that good?
Absolutely.
Okay, good. Reset then. Thank you, sir.
Thank you.
Yeah, come on up. Who do we have?
Mr. Hill?
Aaron Hill? Aaron,
Thank you.
Change the paperwork.
Yeah, we did the.
Right here?
They see you got to put it on there, so.
where did I? So where did this come from? From this document?
Ink up the,
I don't have those.
I have one, Judge, give me a second, ink up your right thumbprint.
We're just trying to fix
Leave
it.
it flat right there, don't roll it. Ink it up one more time.
Oh, it's funny to you.
Being efficient.
You can go stand in front of Judge. It's right here.
Okay. I see a dismissal on 1898 as part of this arrangement.
That's correct, Your Honor.
And that's going to be the theft of a firearm.
Yes, Your Honor, and there was no restitution in that one, just.
Okay, so the other two cases in numerical sequence, 24 CR 351 and 24 CR 1613 are
Yes.
both called the State of Texas versus Aaron Hill.
Yeah.
You have Mr. Hill
Yes, sir.
present with Mr. Turk, your attorney, and the state's attorney does the defendant. We formal readings of the indictments and arraignments here. Can we proceed in summary?
Yes, Judge.
In summary, sir, 351, we'll take that up numerically. In summary, that alleges that on or about January 29th, 2024, in Jefferson County, Texas, you committed a third-degree felony of injury to a disabled individual. Do you understand what you were charged with here?
Yes.
If convicted, you face no less than 2, no more than 10 years confined and in prison, and a fine up to $10,000 can be assessed. Do you understand? The agreement's been reached that you would be pleading guilty, found guilty, sentenced to 6 years in prison to run concurrently with other cases. Is that your understanding?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
So,
How do you plead to this, guilty or not guilty?
yes.
Are you pleading guilty voluntarily and because you are guilty?
You know, yes.
Sir,
Yes.
that's yes. You have to respond to me. That's yes.
Yes.
Okay. I'm gonna hold that one in advance. We're gonna go to the next case and come back to this one in just a moment. All right, in 1613, in summary, this indictment alleges that on or about July 16th, 2024 in Jefferson County, Texas, you committed a second-degree felony of aggravated assault with the use of a deadly weapon, namely a firearm. Do you understand what you're charged with here?
Yes.
A second-degree felony carries with it, if convicted, a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached in your case here where you would be pleading guilty, sentenced to 6 years in prison to run concurrent with other cases. Is that your understanding of the agreement? I have to have an answer today.
Do you understand that?
Yeah. Yes.
If I follow this agreement, you have no right of appeal of your case. You understand? How do you plead to this charge? Guilty or not guilty? How do you plead to this charge? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1 for each of these cases. If you sign those documents voluntarily, understand them, discuss them with your attorney, or the contents all true and correct. State's Exhibit 1 tendered into evidence in each of these cases.
No objection.
Without objection admitted. Among other things, State's Exhibit 1 state similarly that you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true. So help you God. In each case. Is that so?
Yeah.
State's Exhibit 1 made a part of the record for all purposes in each case. Pre-sentence reports waived.
Yes, Judge.
I will follow these agreements. If nothing further to add by anyone, I will make the findings that Mr. Hill, in each of these cases, you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt in each case. I so find you guilty in each of these cases beyond a reasonable doubt. I am following these agreements in 24 CR 351. You are yes. So and you are hereby found guilty beyond a reasonable doubt of this third-degree felony of injury to a disabled individual. And following the agreement, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. Do you understand what has happened in that case?
Yeah.
In 1613, this court finds you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault with a deadly weapon. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. And these two sentences shall run concurrently with other cases. There will be an affirmative finding in this case in the judgment that a deadly weapon, namely a firearm, was used in the commission of this offense. Do you understand what has happened today, sir?
No further.
Anything else?
No, Judge.
Okay, we are in recess on these. There's one other matter, a dismissal.
Yes, Your Honor,
is going
that
to
was
be filed.
a jail felony, the theft of a firearm,
That
1898.
case will be dismissed. 24 CR 1898. That case is hereby dismissed. Two, Pam,
Yes, Judge.
you ready on that?
Yes, Judge.
That's not the problem.
Gotcha. Yeah, that. Do you have those files?
You have, Judge.
I
From the file document.
Back of the.
While you're flipping through there, you've got another plea coming on Prudham. Just trying to help, Judge.
Tupam?
Yes, sir.
Yes, sir.
Am I pronouncing that correctly? Okay.
And he'll have to come swear and fingerprint for me. Raise your right hand. You swear or promise to truth or truth not.
So.
Here goes.
And you have one more time. Let's get that right here.
All right. We call this case 23 CR 2102, the state of Texas versus Tu Hong Pham, present with her attorney, Mr. Kelly, and the state's attorney does. The defendant waive a formal reading of the indictment and arraignment here. Can we proceed to summary?
Yes, we do. And we.
In summary, this indictment alleges that on or about October 23rd, 2023, in Jefferson County, Texas, you committed the third degree felony of assault, family violence with by impeding breath or circulation, by choking is what we refer to that normally. Do you understand what you're charged with in the indictment?
Yes, sir.
An agreement's been reached where you would be pleading guilty to the lesser included offense of assault. Is it FV? Is that family violence?
Family violence.
Okay. And in the indictment, it does state that you allegedly, intentionally, knowingly, or recklessly caused bodily injury to Alona Pham, a member of your family, household, or person with whom you had a dating relationship.
That shouldn't read dating relationship.
I understand.
I need
I'm
to-
taking, well, it doesn't apply, so it's it's not relevant.
Yes, sir.
But the lesser included of intentionally, knowingly, recklessly causing bodily injury to a person who is a member of your family or household, that is a Class A misdemeanor, which means you face up to 1 year in the county jail and or a fine not to exceed $4,000. Do you understand the punishment range for this lesser included offense of assault, family violence? That's a yes or no?
Yes.
Okay. An agreement's been reached. You would be pleading guilty, placed on deferred or unadjudicated probation.
Yes, sir.
Is everybody wanting 1 year? Is that what we want?
That's correct, Judge.
No fine or anything
No
like
fine.
that? Nothing? No other condition of probation?
She's going to have to complete the batter's intervention program.
Okay. Is that
That is
the understanding?
more customary terms.
That would be part of the condition of probation. But is that your understanding of the plan,
Yes, sir.
ma'am?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this lesser included Class A misdemeanor of assault, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir.
I've got on the face of the indictment here, On this date, defendant pleads guilty to lesser included Class A misdemeanor of assault family violence. Any objection to that? All right, I'm going to follow this agreement and then you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. In State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, but the court is going to defer any finding of guilt, place you on deferred or unadjudicated probation for this lesser included Class A misdemeanor of assault family violence for 1 year. There will be terms and conditions of probation, which are normal and customary for this type of offense. And among other things, you shall be required to complete batterer's intervention program as directed. And there are other terms and conditions which are normal and customary for this. You do well, it will be dismissed. You fail, your probation could be revoked. You could then be found guilty of this lesser included Class A misdemeanor of assault and punished up to 1 year in the county jail. So you're going to do well?
Yes, sir.
Good, good. The person that was the victim, who is this?
It's your daughter.
Okay. What's the relationship? Good or strange?
Not really existed since the indictment.
Okay. What are we doing about that? Does everybody want a relationship?
They were honoring the conditions of not having contact, Judge.
I understand. I want to know. What do y'all want to do? Do we want the family unit back or not? Okay. I want to work with that. Tell me what needs to be done. You made a mistake. Welcome. The whole world makes mistakes. Everybody makes a mistake. Fix it responsibly. And this blood relation, your daughter, well, I've got two. And they're certainly precious. And I'm sure you think that way, unless you're an odd person, but I don't think you are. But fix this. But you know what love is all about and how it is carried out in a relationship. But assaultive behavior is not part of the way a family should be, and fix it. Can you? Good. Yeah. Anything else?
No, Jim.
Oh, that is all. Hey, John. Out here. Let's go back and fix this trial docket so we can move on with our lives. Okay. Mr. Ham?
Yes, sir.
You've got a bunch here.
Right there.
You got Richard Hernandez.
Yes, sir.
Is that ready to go?
Yes, sir, it is.
This is a 2-witness. Well, it will be short. The unknown factors how Mr. Hernandez will behave in the courtroom.
I understand. Anthony Woodruff on who's the DA on that one? Me.
I am, Your Honor.
Okay.
We are ready. I do have one officer that can't come in until Wednesday afternoon. But that would be my last witness.
Okay.
We have some issues regarding, we haven't had any notice of any kind. We're still waiting for responses to some discovery.
Well, it's 804 days.
I understand.
They just, on trial dates, not that, that's over 2 years have gone by and y'all still aren't ready?
Well, we're ready, Your Honor, as far as
Then let's
we
move
can with
forward.
regards to, we're waiting on the state to provide us what we've requested.
What have you done about that? It's 2 years. Have you filed a motion for mandation or something from me.
Motion to compel?
Yes.
I have not.
Well, why not? I shouldn't get surprised on the day of the trial that we're not prepared.
Since this belonged to another prosecutor before Kyle took it over,
But
I don't
that's,
know what the issue is, but we can resolve.
The state has provided everything that we have in our possession in this case.
I've reviewed all the defense motions and we are in compliance, Judge. We've asked him specifically through emails through Ms. Gasper to detail what he wants and we got no response.
what about that?
Okay.
Let's move forward.
We're ready to go, yeah.
Okay. All right. And Ellis Tatum?
That's mine, Judge. This one is going to be, of the ones I have, this will be the most lengthy one, Judge. My anticipation is approximately 3 days on the aggravated assault and deadly weapon.
Okay. On Travis, where's John West? I mean, it's on here a bunch, gotta know where this is headed. He was working on some, but some. John. And I've got, Carol Hope is ready. Terry Warren is ready. And then there was something on Damon Sargent.
He was in jail, Judge, which we found out today. He was supposed to, we thought he was on bond.
But he's in jail.
Correct.
So who's the defense on
attorney
that?
is Jennifer Deloche.
Yeah.
Okay, y'all, where are you on that?
Judge, I'm still waiting on discovery.
I heard one before.
An offer.
Mr. Laird,
Is
your
what's-
prosecutor.
Oh, prosecutor, sorry.
Sergeant.
Sergeant.
Okay.
They,
I don't have discovery either.
they didn't have discovery on.
I didn't know she was attorney.
I didn't know who the prosecutor was.
I'll get it.
Do y'all think y'all will work that out?
We may, once you get
I
discovery.
mean, work out on getting that done?
Yes, sir.
I'll get that.
So you're not ready for trial then today? Okay, it's a year. He's, where's Mr. Sergeant?
He's in jail.
He's in jail.
He wasn't brought over because we didn't know that he was in custody.
It doesn't show it,
Yes,
here,
sir.
strangely enough.
Yes, sir.
4 weeks? Reset 4 weeks.
That works for me.
Okay.
As long as, assuming I
All
get
right.
discovery.
Thanks.
Thank you.
Okay, let's take care of, oh, there's John. On Travis Jackson. Travis Jackson, these are all off the trial.
We'll go back to the trial doc.
Yeah, there was no announcements on some of these.
Ready on that one, Aaron.
We showed you having discovery.
Really?
Carrie,
Hold that then. I thought I did. I had it.
are you ready or no?
Let's hold on that one, Your Honor. Mr. Jackson, not ready.
What's wrong?
I thought I was, but
Somebody told you.
Yeah, I've advised him of an important step he needs to take.
Terry Prudhomme?
Terry Prudhomme, we already filled out the paperwork, Your Honor. It
Should have a plea in the.
Okay.
Yeah.
In the.
We'll need Terry Prudhomme, please.
Study Jackson.
Yeah.
Yes.
Yeah. Jackson is to be resent. Prudhomme, please. Ordale Mays.
I'm ready with Mr. West on that, Judge. That one's brief.
Which one was that?
Mace.
Mace, yes, ready.
That's trial.
Yes, sir.
Yeah.
That's,
And then
we'll be done
Mage
Tuesday.
McMillan.
That one's ready, Your Honor, also.
Mr. On Mr. Hope, Mr. Gertz asked for an offer and I haven't seen him since then. On Carol Hope, Mr. Gertz asked for an offer and I haven't seen him.
Okay.
And I need to put him over here, please. Like right hand side. You swear or some sort of. You got your right hand front. Okay, place it flat right there. You get up one more drop. There's the flower right there. Go see it right there.
24 CR 837 is called Terry Prudhomme. That's you, sir?
Yes, sir.
Present with, your attorney, John West, and the state's attorney does the defendant waive a formal reading of the indictment and arraignment here. Can we So.
It's going off
Just
the.
going on one?
Yes, Your Honor. That's-
Paragraph one?
Yes, Your Honor.
Paragraph one states that on or about March 25th, 2024 in Jefferson County, Texas, you committed this third-degree felony of unlawful possession of a firearm by a felon. Do you understand what you're charged with here, sir?
Yes, sir.
A third-degree felony means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
The agreement's been reached. In your case, you would be pleading guilty, sentenced to 3 years in prison. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal.
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Guilty, yes,
So you're pleading guilty voluntarily. That is on your own free will and
Yes, sir.
because you are guilty.
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it. Discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence and without objection?
No objection.
Admit it. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made.
Yes, sir.
You know what you've been charged with. The indictment has read you.
Yes, sir.
You were guilty of the crime charged with any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. Also, so help you God.
Yes, sir.
State's Exhibit 1 made a part of the record for all purposes. Pre-sentence reports away.
Yes, Your Honor.
I will follow this agreement. I'm going to find, if nothing further, Mr. Prudham, you are pleading guilty voluntarily. You are mentally competent to do so.
Yes, sir.
You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of unlawful possession of a firearm by a convicted felon. And you are hereby sentenced in accordance with this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years.
Yes, sir.
You understand what? In that order? That's it? Yeah. And we'll pick it.
Yes, ma'am.
Okay,
But it won't, we'll get.
you ready for it?
Yeah.
Okay, all of those other ones, is that the rest of the crowd market?
No, these are,
Okay,
no.
okay, just making sure. Okay, back up.
Ryan Gertz has a bunch of stuff here that I was hoping he would be present for, but he's not. Earl Keeling. Mr. LeBlanc, up here.
Oh, Judge, Mr. LeBlanc told me that that has to be reset because a new case is coming down into this.
He left really fast to say that.
Is that right, State?
Yes.
Earl Keeling is reset, 4 weeks for review. Thank you.
Just work on it. Yeah. That's the money that's talking about. Yes, sir.
So I've got, Keontae Batiste is reset. Jeremy,
Judge, can we set that for the MPRP hearing? That's been up before and there,
all right,
my perception that.
all right, I want that next Friday MTRP hearing or next week. Put it for Monday for our hearing. Thank you.
I'm done with that.
Bruce Smith, not here. On Crystal Vaughn.
We already prepared that.
Do you have the file?
Yes, we've already, we ordered documents on, with her.
Okay. Aaron Hill, I've got that. What did we read?
Did it through, Judge?
Here, that's already done.
You gave me the other
Two cases, yeah, and that was the third one. Desmond Sargent.
That was on the trial docket.
Here,
Let me reset that.
here's James Franklin. Ms. Gertz, two cases that. Lower Ryan Lynn. And. Kendrick Leday. Here. Those verses, I think those go back to you. I have John Bordash. With John. Gabriel Caldwell, I mean, John. Akeem Harrison, John. Michael Johnson, John. Todd Robertson, John. Frederick Wilkes. John, then I have. What are y'all here on? Or you have something?
It's Ellis Tatum on Chicago.
Oh, okay,
I think December 4.
okay. Well, you know, I don't need you back till 1.
He has nowhere to go. He has no life, no friends.
And I have Jonathan Cruz on a withdrawal.
I see. It's Jonathan Cruz.
Yes.
Come on up. You gotta find John West. He's got a bunch of stuff. Here.
Bruce is in custody.
What are you gonna do?
I'm seeking to withdraw on that case.
Cruz, please. Thank you. Anthony Woodruff. Where was Anthony Woodruff?
Oh, Judge, that's the trial docket.
Yeah.
2 cases, that's only
Here.
one file.
This is the other one. Okay, you were Jonathan Cruz?
Yes, sir.
24 CR 565 is called, you were charged, as you know, with the state jail felony of theft. And then the indictment goes on to allege you have 2 prior convictions of state jails, and then this state jail felony then becomes a 3rd-degree felony for punishment.
Yes.
If all of this is true, if you're found guilty. And then you're looking at no less than 2, no more than 10 years confinement in prison and a fine up to $10,000. You understand?
Yes, sir.
All right, so here, Mr. Wilkerson has been your attorney. Are you detained on this?
Appointed, Your Honor.
Appointed. All right, go ahead. You filed a motion to withdraw
Yes,
here on August 21st. Go ahead.
Your Honor, so in this case, we have attempted, endeavored to satisfy all of Mr. Cruz's requests and representations exhaustively, from contacting parole officers at his request because of a revocation warrant on file.
You do a good job. You are pretty intent on taking care of business.
To issuing subpoenas to phone carriers, in a number of other locations. Ultimately, it comes down to a conflict that is renders this attorney-client relationship unworkable at this point. There are issues ranging from allegations that the dates on various offense reports or rental contracts or things of that nature are wrong, to even more in-depth issues. And so our last in-person meeting devolved into a loud exchange, Your Honor. I don't know what more I can do in service of representing Mr. Cruz. I believe it's in his interest and the interest of justice that another attorney be appointed to represent him on this matter.
Okay, so what happened? What's the blow up that happened on the last? Because I don't expect defendants to be mistreated. And I certainly don't expect my lawyers to be mistreated.
Yes, sir.
That will have severe sanctions. I can hold people in contempt of court because attorneys are going to quit wanting to represent people, and then good luck with the Constitution then if you can't be civil with a person who's working for your best interests. He's saying what he's saying. I don't believe him to be a liar and a man who is dishonest. He's never been that way to me. You can put that away.
This is a document that says that I gave him a number. This is from the emergency response to T-Mobile. He tells me that the company says that it's no record of such. And the company, this is a subpoena that says, know what, the attorney gave them the wrong
That is
phone number.
right there.
No, this is the wrong, he asked them to research the wrong phone number.
Okay.
And they saying that he gave them the wrong phone number. So that's not my phone number.
Okay.
And they say it's right
Are
here.
y'all trying to fix that?
It says, please have your attorney correct the
Hold on,
target
he's
information.
talking. Let him talk. Go ahead.
It says, please have your attorney correct the target phone number and issue a new legal.
Okay.
So they saying that I have a phone number with you.
Okay.
But
Relax. Let me look at this. What's the, this is on August 11th?
Yeah.
Okay, T-Mobile hereby objects to the reference legal demand and is unable to respond. Which is not service. Okay. You've seen this.
No, Your Honor, but we issued subpoenas for two different phone numbers based on our client's representations of what numbers belonged to him at the time. We received one affirmative response, to which we received a list of incoming and outgoing calls. I reviewed that with the client. He insists that other calls were made that are not shown on that record. The other phone number I subpoenaed was the number that was provided to me by my client in a number of different communications. This is just a series.
What about that?
Ongoing.
Did y'all receive information from the phone company on that?
We were, as indicated, Judge, we received one response with records, and we received another response with regard to the other number that he provided, saying that there were no records associated with that number. There are issues regarding the contract that was executed,
contract
allegedly to rent a vehicle.
It's just the basis of this charge.
Which serves as the basis of this charge. There are issues regarding offense reports submitted by other agencies to the Department of Public Safety, in which the defendant alleges that the reports contain inaccurate information. It's not a workable relationship, Your Honor. And I would just again urge the court to appoint a different lawyer, perhaps who might be able to communicate with this defendant in a way that I seem not to be able to do.
Judge Stevenson, with all respect, sir, this is what I want, this is what this is what I seriously need. I want him to show you one document from the text dot police, from the text dot police. I was in an accident with Enterprise Run. I was hit in the vehicle. In the text dot report is wrong. It says on that document, if an officer was on arrive, if a Dallas police officer arrived at this scene, then what is their final conclusion in the narrative? It says that an officer is flagged down, which means I called Dallas police, which means Dallas police to have a police report. He's going to text dot instead of Dallas police. You have Dallas County Sheriff that recovered the vehicle, and then you have Dallas police who actually wrote the dude that hit the Enterprise rental car called driver's side and passenger side damage to the car. I had counsel, I had a beat counsel in here, and I had a left hip injury. I'm trying to get, then he tell me this, Enterprise rental is offering me 170,000. I told him no. Then he say Enterprise rental is offering me 230,000. I told him no. You more important, you more worried about the saleable instead of criminal. For them to be offering me something like that, let me get on the streets. I'm not absconded. I can go get my own records and I will show you. That's why I'm asking, can you please let me see that takedown report so I can present this to Judge Stevenson?
So,
Okay,
as
what do you
can-
say to that?
There is a text dot report that comes from the Department of Public Safety regarding the accident that took place in Dallas. The report date on the report is from August 24th, I believe, of 2023. I believe the state also has a copy of that document. It was submitted with the
What was the day of the report?
The day of the report was August 24th. It was in the documents. that
So
came
that's
from-
before this event occurred.
No, Your
The
Honor.
indictment, the indictment says on or about October 2nd.
Oh,
This
excuse me.
crime occurred.
No, okay, so
Yeah, I've seen that.
the offense report was made in October, but the offense itself,
Take your time.
the initial rental took place on August 17th of 2023, which the defendant also indicates or alleges is an incorrect date. And again, Judge, I mean, I don't even know where these numbers about hundreds of thousands of dollars are coming from.
Just
Look,
with all due
look,
respect, Judge
yeah.
Stevenson,
with all
this is my first
respect,
time ever in life bringing the rental car. This date happened August 13th. I came back down here.
the facts don't have a lot to do with me unless you want to go to me for a trial. You want a jury trial. It's for the jury to decide what the facts are. Right here, what I want is a defendant and the attorney to work together unless you want to represent yourself.
That's another issue, Your Honor.
Is that right?
He alleges that he is entitled to hybrid representation. Judge, this is the offense report.
Judge Stevenson, it says
I don't need
right
to see
there.
it. Hey, yeah, you know what?
Damn.
You know
So that
what?
means that it's a Dallas police report and he refusing to go get it. That's the
Sit over there. You're in timeout, Mr.
It's
Rude.
right and wrong.
You're in timeout, Mr. Rude. My goodness, no. That we learned in first grade, don't speak over other people like you're doing to me. You want me to hold you in contempt? I can put you in contempt and that would add time to whatever this is. Don't be rude.
I'm saying, how you tell
Don't
me that
be
you don't wanna see
rude.
it? That's
I
my-
just said, you're gonna have,
It's my case. When you tell me I don't want to see that, you refusing my rights.
All right.
That's what you gotta do.
you're held in contempt. You are now placed back in jail until you can act properly, Mr. Rudeness. Mr. Rudeness, go back inside. Thank you. All right. Yeah, well, you got your work cut out for you. What do you want to do?
I would like to withdraw from the case, Your Honor. The change that the defendant initiated with the court just momentarily is illustrative of every exchange that occurs in person between myself and the defendant.
Well, why would it be any different with anybody else, do you think?
Well, I have to believe that there is someone out there who can speak this defendant's language and make him understand.
Although it's a rude form of the English. All right, who's next on the trial? All right. All right, I'm gonna grant you relief. Put you out of your misery. But from time to time, we have obstreperous clients. They're very difficult, but maybe another one will be have some better results from his responses, because he's obviously angry, and he certainly acts rude, and he certainly wants to control the situation on his terms, which is not the way the rules of evidence and the rules of law work. Everybody gets a fair opportunity to be heard, including him, but he can't overpower everyone else and try to control the proceedings by speaking over everyone and shouting. So hopefully, next person on the list will be appointed to represent Mr. Cruz, and I allow Mr. Wilkerson relief. He is requesting.
Thank you. Excuse?
Yes. Okay, I have John West on a bunch of things. Where's John?
Judge, last time I was seeing him was waiting, maybe I've gone out to start. He's very quick trial.
No, he needs to be here, please. Oh, the drug court's, I'm the supervisor of the drug court, and this lady next door. We're waiting on John. We have, drug court can wait. Yeah, he needs to be here. Please get him. Thank you. Okay, thank you very much. We're at short recess. Thank you. Tried case. We only try one at a time, which is what we do. And this trial lawyer, that's what I did. So this is the state of Texas versus James Michael Franklin Jr. That's you?
Yes, sir.
Present with Mr. Gertz, your attorney, and the state's attorney. What are we here for today?
Judge, we want to just place it on the trial docket.
Yeah.
He said get it as soon as we can. He
Who's
has
it?
asked,
That's gonna be you?
Yes, Judge.
All right.
he's asked me to ask the court to consider a speedy trial as quickly as possible. I know that you've got a number of other cases that are older than this. I've explained that to him, gone through the process with him. But he wants
to
Well,
be
nobody,
expeditious.
everybody knows, we've tried 600 jury trials here.
Yes.
Find someone who's done that. I enjoy trials. I learned something new. I'm a trial lawyer. That's what I did. And so I'm the last judge afraid to try a case. We only try one at a time, which is what we do. And this 1029, the aggravated assault, we'll set that one first. Good. And then we'll see where that goes. But we'll set it for trial. When can the state be ready?
4 weeks.
I'm anxious to, 4 weeks, good. What do we have in 4 weeks, please?
It's Thanksgiving.
Second week in December. It's the.
I'm out then.
Ma'am,
I'm not, I will not be here that week.
when, I want to try this before the end of the year. When,
I could do the
Okay.
third week of December.
Yeah,
December.
Yeah.
week of the 15th.
of what?
December.
Everybody be ready?
Yes, sir.
All right,
Yes, Judge.
I'm set for that.
Yes, sir.
Oh, by the way, one other thing. The, get the defendant out. Oh, who? The victim in this case is named, and does the defendant know the victim?
No,
No, okay, all right. That's all.
this is
I just wanted to make sure there wasn't, people working together here who aren't supposed to be interacting by law and rule. All right, and then John West has his cases here. We gonna move any of these, do y'all think, on John's? He's gonna be here in a second.
Mr. Bordock, there's a status hearing.
What?
It's a status hearing to determine what needs to happen. It's mental health. You reset it 1 week left. I don't know if you want to.
He had an idea about his doctor,
And-
but there wasn't a plan in place to do something about it.
You reset it a week for to figure out if it's more concrete plan of care.
English ass. And he's just.
Still. Which makes it, which level to take a stand and go, so how's that parole hold going for you? And here's the habitual, cool. Where's the back of this one? Looks like it's good priors, they're not old priors for matching, covers the priors, fingerprint. They should have the piece, yeah. Key, the tags that I didn't put me, so. I did solve it this evening. When you put through, you don't have to squint, they're good. He's following to the old phone with the days out, charges. If he squints or gets his glasses out or phone out, or if he starts pulling, charger discharge. Oh, I knew they were.
Yeah.
No.
Not.
I just want to make sure, I'll make sure my business will testify.
in February.
Which one? What that do?
Also, after
Your Honor, the state would request that the court take judicial notice of the court's bond forfeiture docket.
I will do that.
And we'd also request that the court take judicial notice of the bond forfeiture case and of the underlying criminal case of the court's files.
I'll take judicial notice of both of those as well,
Thank you, Your Honor. We'd ask that the court enter judgment according to the court's docket,
and I will do that as well.
and we have prepared judgments.
Thank you very much.
Thank you, Your Honor. May we be excused?
Yes, sir. Have a good day. I believe it's already October 20th.
I know, that's what I said about that.
All right, if I call your name, please come forward. Bart Thibodeau. Good morning, sir. You're Bart Thibodeau? And Mr. Thibodeau, were you able to get a lawyer hired?
The one I've been communicating with, I just started my new job this morning, after I get out of here, 30 days wasn't near enough time, around that $4,000.
Where are you starting to work?
Called dealership control.
Let me look at something real quick.
I have a rent house, it's giving me a float barely, but I mean.
As a condition of your bond, were you required, or did I or the magistrate require you to wear a drug patch? Okay, you've been getting that done like you're supposed to.
I can get it off, because I mean, now that I'm working 5 10s over there at that dealership.
You're not gonna get it off as long as this is pending. So what I'm gonna do is give you 30 more days. Who are you talking to?
Justin Gilmore.
Okay, so I'm gonna give you 30 more days to try to get him hired. If it's not gonna work out with him, then talk to at least 3 others.
Don't talk to like 10.
Okay.
They all want the same thing.
Okay, let's see what you can do in the next 30 days. Also, bring me a pay stub since you've started working, and then we'll see what your options are at that point, okay? All right, step in front of the clerk, please, sir. Daryl Albritton. Morning, Mr. Parker.
Morning, Judge.
Good morning, sir. Are you Daryl Albritton?
Yes, ma'am.
And Mr. Albritton, did you get someone hired?
Well, I'm still looking. The good news, they got me working 7/12. They could just started, so I could be able to afford one.
Good.
They high.
Yeah. So who are you thinking about hiring? Or who'd you talk to at least?
Well, I had talked to all of them.
Can you tell me who they are?
Justin, Orlando, Tristan, Grady, Michael.
Are you just telling me their first names? Tell me the
No,
full.
their first name and their last name.
Michael Trent.
Yeah.
Tristan LaGrange.
Where are they?
Orlando Mila.
2 of them in Harris County.
Okay.
The rest of them are in.
Okay. So,
Some more too.
okay, so I'm gonna reset your case one more time. It sounds like if you're working that much, you should be able to get somebody hired before. You've been coming for a little bit. It's time to get someone hired before that next court date, okay? All right, step in front of the clerk. She'll give you a reset notice. Ryan Ramey. Good morning, sir. Are you Ryan Ramey? And Mr. Ramey, this is your initial appearance and cause number 25 DCCR 1246. You're charged with the state jail felony offense of driving while intoxicated with a child under 15. And that's from December 25th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Are you working? All right, so since you've made bond, I expect you to at least try to hire one. So what I'm going to do is reset your case for about 30 days.
If you get someone hired before that next court date, then bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of those that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. Tori Anderson. Good morning. Are you Tori Anderson?
I'm Tori Sam. It's a mistake.
What is it?
Sam. They didn't put my correct last name in there. That's my
Okay.
maiden name.
What's your date of birth?
August 14th, 2003.
All right. And so this is your initial appearance. Is it Sam? Anderson's your maiden name? Okay. So Ms. Anderson, in clause number 25, DCCR 1165, you're charged with the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from July 31st of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, I'm unemployed. I had family come together to pay for my bond.
Okay. Have you been looking for a job?
Yes.
Where have you been looking?
Walgreens, Dollar General.
Okay.
Basic retail business.
All right, so what I'm going to do, Ms. Anderson, I'm going to give you about 30 days to see first if you can get a job. So I want you to be applying to at least 5 a week. You should be doing more than that. If you get a job, bring me some proof of that when you come back. If not, bring me proof of where you've applied, okay? In the meantime, also, I want you to be talking to some attorneys so you know how much they cost. And bring me the names of those you've talked to, then we'll discuss what your options are, okay? So if you still haven't found a job, there may be a time when you qualify for a court-appointed lawyer, but I want you to at least go through this process. I want you to try to get a job, and I want you to try hard before that next court date, okay? All right, step in front of the clerk. She'll give you a reset notice. I should have tested.
Here, hold on. Thank you.
I should have tested. You heard lucky day. Terrell Coker. Good morning, sir. Are you Terrell Coker? And Mr. Coker, this is your initial appearance in cause number 25 DCCR 1221. You're charged with the state jail felony offense of solicitation of prostitution from March 28th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Uh-huh. Okay. So what I'm going to do, Mr. Coker, is reset your case about 30 days to give you some time to get him or someone else hired. All right, if you get him hired or whoever, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you a reset notice. Tiffany Elair. Good morning, ma'am. You're Tiffany Elair? And Ms. Elair, were you able to get someone hired? Mm-hmm. Speak up just a little bit.
I had to resign.
Okay.
I took money out of my TRS to go ahead and pay for a lawyer.
Okay.
Instead, I'll be meeting with him in 5 days.
Okay, perfect. So what I'll do is give you 30 days to get him hired. Bring the reset notice that you get to him and he'll tell you what to do. If for some reason that's not gonna work out, then make sure you either get someone else hired or visit with some others and bring me those names, okay? All right, it was, Kyle Walker. Jalen Eli. Good morning. You're Jalen Eli?
Yes, ma'am.
And Mr. Eli, this is your initial appearance in cause number 25 DCCR 1004. You're charged with the state jail felony offense of forgery of a financial instrument, and that's from August 8th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am.
You already hired someone?
I ain't hired no one, but I'm, like in the process of hiring.
Okay, who are you gonna hire?
Brock,
Burbank?
yeah.
Okay. So what I'll do, Mr. Eli, is reset your case about 30 days to give you some time to get Mr. Burbank hired. If you get him hired before the next court date, just bring the reset notice. You need me? Oh,
You need me now or?
no, I'll come visit with you later, thanks. If you get him hired before the next court date, I had to rewind for a second. Did you see that? It happened. If, just bring the reset notice to him, he'll tell you what to do. If for some reason, go ahead.
Oh, I was saying, I work at FedEx long with 5 hours from Monday through Friday, so it's 30 days, it's kind of hard for me to get to that.
So it's gonna be a little bit longer anyway, just holidays and things like that. If you're not getting enough hours, you might wanna go out and try to get another part-time job or something like that as well. Perfect. So just see what you can do to get him or someone hired before the next court date. If it's not gonna, if you make payments toward him, then bring me receipts. If you're working, maybe bring receipt, your pay stub, so that I see how much you're working. Bring whatever you can bring me that will help, okay? If it's not gonna work out for some reason with Mr. Burbank, then visit with at least 3 others. You'll see they all charge different amounts, have different payment plans, and we'll discuss your options when you come back. If you do all that and need some more time, then we'll work with you, okay? All right, step in front of the clerk. I literally went, I did. It helped. Whatever it takes. I do need to visit with him about that. Crystal Latulas. Good morning, ma'am. You're Crystal Latulas. And Ms. Latulas, were you able to get someone hired? All right, who'd you talk to? The what? Say the last one?
GERTZ.
Oh, Gertz, uh-huh.
Law firm, and a man named James Macon.
Uh-huh. All right, and so where are you gonna be able to get somebody hired? Are you working? Okay, where you work? Okay, so what I'm gonna do, thank you for doing what I asked you to do. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're gonna swear under oath that it's all true and correct, okay? Step in front of the clerk and she'll give you that. Lisa White. Lisa White. Good morning, ma'am. You're Lisa White. Come on up. And Ms. White, were you able to get someone hired?
I went to and paid for a consultation with Mr. Rojas and Mr. Samuel and Mr. Cole Construction, $30,000.
Okay. And are you working?
I started unemployment this week.
Okay. So what I'm going to do, Ms. White, thank you for doing what I asked you to do. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely because you're going to swear under oath that it's all true and correct, okay? Step in front of the clerk. She'll give you that. Looking at her PC. It's aggravated assault. She chased down another lady and hit her with her car twice. Yeah. Just gonna dry those tears real quick. Rakeem Allen. So weird, like his didn't print together on the docket. This one? Good morning, are you Rakeem Allen? And Mr. Allen, this is your initial appearance in cause number 25 DCCR 1163. You're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from June 7th of 2025. And then in cause number 25 DCCR 1164, you're charged with possession of a controlled substance, and that's also from June 7th of 2025. Since you've made your bond in your cases, have you had an opportunity to try to hire a lawyer? So have you hired someone?
Not fully, but he basically my lawyer. I go pay him today.
Who's that? Okay. And are you wearing a drug patch?
No, no.
Were you ordered to wear one?
I was, but once they changed my bonding company, they professionally didn't tell me about lunch.
So, but the magistrate told you you had to wear one when you got out of jail, right?
No, I'm on 2 different bonds. So I guess the other bond I was on, I had already got done paying them off, so I didn't have to pass for them anymore.
Okay, so you're gonna have to wear one for me, but what first we're gonna do this morning is have you tested to make sure you're clean. Have a seat in the jury box. Well, because on this docket, it shows on together. Oh, gotcha. Can you tell, can y'all look back on that possession case at the bonds from the jail for me real quick and just see if the conditions were written in on that one while I'm. Terrence Currington. Good morning. Are you Terrence Currington? And Mr. Currington, this is your initial appearance in cause number 25 DCCR 1114. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from July 13th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? I'm sorry? Okay, so what I'm going to do, Mr. Currington, is reset your case about 30 days to give you some time to try to hire someone. If you hire someone before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, step in front of the clerk right here. She'll give you a reset notice. Kayla Provost. Good morning, ma'am. Are you Kayla Provost?
Yes, ma'am.
And Ms. Provost, did you get someone hired?
I've been talking to Mr. Langston.
Okay.
And I reached out to my temporary, but I think I'm gonna go with Langston.
Okay.
However, I haven't got a job yet, but my teacher, I had graduated school like 5 months ago.
Uh-huh.
And she reached out to me for an internship that was supposed to start today.
Okay.
So.
Is it a paid internship or?
Yes, it's supposed to be paid.
Okay.
For phlebotomy.
I'm sorry?
For phlebotomy.
Okay.
So, yeah, I was gonna reach back out to her to see if I could start tomorrow.
Okay. So if, what I'll do, Ms. Provost, is I'll give you another reset to get you hopefully started on that job and where you can hire one of those attorneys. If that works out great, just get them hired and bring the reset notice to them and they'll tell you what to do. if for some reason it's not gonna work and you're not making that kind of money or whatever, bring me a copy of your pay stub if you are working, and talk to some other attorneys and bring me those names, and then we'll discuss your options, okay? All right, step in front of the clerk. She'll give you a reset notice. Oh, really?
But it just says standard bond conditions on the left.
And see, that is, but it should, standard bond conditions for a drug case are different. You know,
Right. That's why it's not.
maybe, make a notation to see if, Christy can locate those. Whitley Shepherd. I still smell coffee in my hand. I have to wash my hand. Good morning, you're Whitley Shepherd. Okay, and Ms. Shepherd, this is your initial appearance in cause number 25, DCCR 1146. You're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from June 1st of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do, Ms. Shepherd, is reset your case for about 30 days to give you some time to hire one. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers you've talked to when you come back, so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? Also, a tracksuit type thing is not appropriate for court. You need to wear something else next time. Do you understand? Yes, ma'am. Step in front of the clerk. Kyle Whittington.
David Jones.
Good morning, sir. You're Kyle Whittington. And Mr. Whittington, this is your initial appearance in 2 cases. The first is 25 DCCR 0924. You're charged with possession of child pornography, and that's from July 29th of 2024. And cause number 25 DCCR 0925, you're charged with online solicitation of a minor under 14, and that's also from July 29th of 2024. Since you've made bond in your cases, have you had an opportunity to try to hire a lawyer?
Not yet.
So what I'll do, sir, is reset your cases for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to when you come back, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, to step in front of the clerk, she'll give you a reset notice.
I'm doing 5 things at one time.
So Sunny earlier. See, Mr. Comerford. Good morning. Are you ready on Farrell Gilbert? Is it Farrell, probably? Farrell? Let's see. It's Mr. Smith? Farrell Gilbert? Good morning, sir. Are you Farrell Gilbert? Is it Farrell or Farrell?
Farrell.
Farrell Gilbert. And this is cause number 25, DCCR 1009. Mr. Gilbert's charged with driving while intoxicated, third or more. And what is the announcement?
I just picked up the media footage today, so I just need some more time reviewing that.
Sure. Any issues? So, Mr. Gilbert, I'm going to reset your case about 30 days or so. Make sure you make an appointment, go visit with your attorney now that he's gotten all of the media. Y'all can go over everything and we'll see if we can get an announcement at the next court date. All right. Thank you. Y'all are free to go.
Thank you, Judge.
See, Mr. Parker, you've got Dalton Frege. That was Farrell Gilbert. I want to rename him. Morning. That's crazy. You're getting old. Good morning. Are you Dalton Frege? And will your client waive the formal reading of the indictment? Mr. Frege, in cause number 25, DCCR 0404, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from February 6th of 2025. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you actually did what they've charged you with?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Frege is not competent?
There you go.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. It'll just give me more information about you and your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation before you leave the courtroom today, and she's sitting at that desk right over there. Okay, we'll see you back at sentencing.
Thank you, Your Honor.
See, Valerie Hale. Good morning, Mr. Warren. Good morning, you're Valerie Hale. And will your client waive the formal reading of the indictment?
You got it. I don't think I put on the paperwork the interlock judge, but that's part of the plea agreement.
Okay. All right, Ms. Hale, in cause number 25, DCCR 0573, you're charged with a state jail felony offense of driving while intoxicated with a child under 15, and that's from March 13th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. Order to pay a $1,000 fine and to follow all of the rules and conditions of probation, including having an auto ignition interlock device on your vehicle. Do you understand? Do you have one now?
Yes.
Okay, I was about to say, you should already have one, and so that'll be part of your probation, at least for some amount of time as well. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number
No
one.
objection?
It's admitted. Is there any evidence that Ms. Hale's not competent?
No, Your Honor. We'll waive the PSI.
What kind of history, if any?
Absolutely none, Judge.
Okay.
Just go to my.
All right, so Ms. Hale, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea. Waive the pre-sentence report, find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of driving while intoxicated with a child passenger. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and condition of probation, including continuing with that interlock device until further order of the court, okay? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. And so this is for you, for this probation, this is for all practical purposes, your case here in court is over. And you'll be able to serve that 2 years while you're out on probation instead of in the state jail prison. And if you do everything correctly, you'll never be back in court. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing that 2-year sentence that you've agreed to. Do you understand? All right, you just need to have a seat here in the courtroom. Probation, she's in at that desk right there. She's going to call you up when she's ready to go over your paperwork. Okay? Yes, ma'am. Good luck. David Jones. See Mr. Smith on David Jones.
I don't know. It's from Mr. Hoffhauer.
Oh, I'm sorry. I read the wrong one. It's Mr. You're right. Let's see. Good morning, sir. Are you David Jones Jr.? And Mr. Parker, will your client waive the formal reading of the indictment? Mr. Jones, in cause number 25, DCCR 0124, you're charged with the state jail felony offense of solicitation of prostitution from December 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak up, please. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
And with regard to history?
He has one arrest for a misdemeanor 12 years ago, Your Honor.
So no objection to me waiving the pre-sentence report?
No, Your Honor.
Mr. Jones, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. I'm going to waive the pre-sentence report, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, if you're successful, the case is dismissed. You'll never have the conviction. The other side of that is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could go to the state jail prison for up to 2 years. Do you understand? Also, if you get started on probation, you do everything you're supposed to, get the community service out of the way and do everything else, then I sign early terminations all the time as well. And so there's no reason that you wouldn't get off early if you do everything you're supposed to as well. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I hinted on something I didn't need to. There we go. All right. You just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. She's sitting at that desk right over there, so just watch for her to call you up. Okay? Good luck to you, sir. I don't know what's up. Your thing's off again. So if y'all will put a ticket in and remind me to call, we've got to do something to get it fixed. Christopher Morale. Good morning. Are you Christopher Morale?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment? Mr. Morale, in cause number 25 DCCR 0466, you're charged with the third-degree felony offense of continuous violence against the family from February 8th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am, I did.
And do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, including entering and successfully completing an anger management program. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Morale is not competent?
Negative.
And as a condition of your bond, is it already, you should already have a condition that you're not to have any contact at all with Alonda Kelly?
Yes, ma'am.
Okay, so I want to make sure that you're still under that bond condition, that it will likely be a condition of your probation as well.
Absolutely.
So I want to, if you violate that and have any contact or communication with her whatsoever before sentencing, then I don't have to accept this agreement. Things could be much worse. Do you understand?
Yes, ma'am.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at sentencing. Thank you, Mr. Parker. Mhm. Mr. Allen? When did you smoke marijuana last? So here's the thing, you need to tell me the truth, because I'm going to get a quantity amount, not just that you're positive, but I'm going to get how much is in your system. And so I need to know when you smoked it last, so that if I find out next time it's not going down, things are going to be worse. So when did you smoke? When did you smoke last? Day before yesterday. So that's why you weren't wearing your patch.
No, really, I
I said, I'm on 2 different levels. I was already done doing my first one.
Right.
And I'm gonna sit on the first bill, and I was on, that's what my blood pressure is. I figured since I wasn't paying the bill anymore, I had to let blood pressure. They haven't been
I know, that'd be really convenient if you had 2 felonies and you didn't have to wear a drug patch and you could smoke marijuana 2 days before court. That'd be pretty convenient, wouldn't it? So you're gonna have a drug patch today, within 24 hours. I know the first one will be positive, obviously. If the next one is not going down, then your bonds in each of your cases will be raised and you will be back in custody. No questions asked. Do you understand? So you have 24 hours. I want you to get confirmation of that to your bondsman. Even though you've paid your bondsman, they're still your bondsman. They're still going to give you, just because you paid them off doesn't mean they're not your bondsman anymore. Okay, so even if you pay off the other one, you're still out on bond. You're still required to keep in touch with them. They're the ones that'll help you figure out when your court days and all of that stuff. So don't stop communicating with them, because even though you've paid them, they can get off your bond and you can go back to jail. So keep up with everything you're supposed to. I want proof to them by tomorrow or this afternoon that you have the drug patch. You need to make sure it's switched every 2 weeks like it's supposed to. Wear it properly. There's no going in and saying, well, it fell off, and none of that. Okay, well, that makes me more concerned about your decision making if you were doing well and then you decided right before court to go smoke, right? Okay, step in front of the clerk. She's going to give you a reset notice. You need to get a lawyer hired as well before that next court date. Oh, sir. That's not appropriate. First of all, pull them up. I know. Well, nobody wants to see your underwear. Not in court and not anywhere. Does anybody ever want to see your underwear? Right? And you need to wear something nicer when you're coming to court. Yes, ma'am. Sure. Uh-huh. And how do you plead to that? Mr. Vasquez, you have Veronica Randall.
Yes, sir. Can we hold all that?
Yes, sir. Mr. Rojas, Michaela Marcantel. Morning.
Good morning. We've emailed the attachment.
Okay, thank you. Good morning. Are you Michaela Marcantel? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Let me get to it. Ms. Marcantel, in cause number 25 DCCR 0528, you're charged with the state jail felony offense of theft of property from May 28th of 2022, continuing through June 4th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be $4,492.45 to be paid back in restitution, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Marcantel is not competent?
No, Your Honor.
And any reason
She's
not to
never been
wave?
arrested before, Your Honor. I don't
We've
have
got the
objection to
amount.
waiving.
All right, Ms. Marcantel, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. I'm going to waive the pre-sentence report. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 5 years. You're ordered to follow all of the rules and conditions of probation. I'm also ordering you pay back the restitution in the amount of $4,492.45. If you do everything that you're supposed to on this probation, this is an excellent opportunity because you are not a convicted felon. You don't have the conviction on your record. And if you successfully complete the probation, at the end, the case actually gets dismissed and you'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for up to 2 years. Do you understand? That's a lot of money to pay back also. 5 years seems like a long time to pay it back, but it'll sneak up on you. And so it is very important to me that you start paying back that money immediately. Even if you pay a little bit a month, it'll add up. What can happen is you can do everything else you're supposed to on your probation. And if we get to the end of the probation period and you have not paid that restitution back, and I make a finding that you could have, you could still get revoked to go to prison after you've done all that probation. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation, she's sitting at that desk right there. She's going to call you up when she's ready to go over all of your paperwork. Good luck to you, ma'am. Carnell Beard, excuse me, it's a sentencing, Mr. Rojas. Good morning, sir. You're Carnell Beard?
Yes, ma'am.
And Mr. Beard was previously in court. You entered a plea of guilty to collision involving serious bodily injury. And I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Any additions or corrections?
No, Your Honor.
There was a notation that restitution was to be determined, but I didn't see that there was any. Ms. Malfino, does the state have any notation or request, or did I miss it?
I never, I did send Mr. Davis to complain in a restitution request form. I have not ever heard back on that.
Okay.
So at this time, I don't feel like I have something to stand on to order.
Okay. All right, then, Mr. Beard, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. And if you do that, this is an excellent opportunity because you don't have the felony conviction on your record. And at the end of the probation period, if you're successful, the case is actually dismissed and you'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could go to prison for up to, is it 10? I'm sorry.
Just
20.
so the record is clear, it's 20. We
20
pled
years.
to count 1 and 2.
Okay, so you could go to prison for up to 20 years if you violate your probation. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you when she's ready to go over all of your paperwork. All right, good luck to you, sir.
Thank you.
Thank you, Mr. Rojas. Let's see. Mr. Kimler, are you ready on Brianna Kleinen? Okay, I'll hold it. And then what about Ryan Hodge? Okay, I'll hold that as well. And Richard Robb?
furthest way here.
Judge, we've come to a resolution on that, if you may, just, there's no restitution that was determined, and so I think we have it resolved, other than in this court.
Other than what, I'm sorry?
Other than that here, Judge.
Oh,
We
okay.
can Take it on the hard documents.
Okay, y'all are gonna take care of it down the hall?
Yes.
Okay, so I'll just do a normal reset to give y'all time to get that done. If it gets done, just let me know and we'll sign the dismissal when it comes through.
Okay, thank you.
Thank you. Let's see. Mr. Galmore, you've got Kelton Hebert. Good morning. How are you?
Fantastic.
Are you?
It's Monday morning.
It is. All right, sir, are you Kelton Hebert?
Yes, ma'am.
And this is 24 DCCR 1498. What is the announcement?
Judge, if we could have 2 weeks, Mr. Hebert was not able to come to my office since our last court date. There's a particular video he needs to watch. He's been working too much, but we'll make those arrangements if we can just have 2 weeks.
Okay, so this will be the final reset. You need to figure it out. I appreciate that you're working, but find a time to go visit with Mr. Galmore before that next court date. It'll likely be 3, just because we're down, but,
I looked at my calendar, both of those are fine.
okay, all right. Stay in touch with Mr. Galmore. We'll see you at the next court date.
Thank you.
And then you have Duma Turner. This is Mr. Hoffpowers. Good morning, sir. You're Duma Turner?
Yes, ma'am.
And in 24 DCCR 1998, Mr. Turner, you're charged with criminal mischief, and what is the announcement?
Judge, if we could just have a normal reset on this one, not had an opportunity to review all the discovery yet.
Looks like you were just got on in August. Any issues that you see?
No, Judge, it looks like, there should be an offer in there and the restitution amount has been determined.
All right, so Mr. Turner, I'm gonna just do a normal reset, about 30 days or so. Make sure you visit with Mr. Galmore before that next court date. We'll see if we can get an announcement.
Sounds good.
All right, you're free to go. Thank you.
Judge. That's all I have.
Thank you, sir. Have a good day. Mr. Macon, you have Thomas Fisher sentencing.
He's present, Your Honor. Good morning, Your Honor.
Good morning. Good morning. Are you Thomas Fisher?
Yes, ma'am.
And Mr. Fisher was previously in court and entered pleas of guilty in cause number 23 DCCR 1046 to aggravated assault with a deadly weapon and 23 DCCR 1047 criminal mischief, a state jail felony. I've received that pre-sentence report. Has everyone had an opportunity to review that?
Yes, Your Honor, we have.
Are there any additions or corrections?
No, not by the statute.
All right, sir, I'm going to find in each of those cases that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence in each case to find you guilty. However, I'm going to follow the agreements in each case. In cause number 23, DCCR 1046, defer all proceedings for a period of 5 years, place you on probation. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And then in cause number 23, DCCR 1047, also defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine in that case as well, and to follow all of the rules and conditions of probation. This is an excellent opportunity because you have no felony conviction on your record. And so if you successfully complete the probations, then you will never have felony convictions. And at the end of the probation period, the case will be dismissed. One of the conditions of your probation is going to be that you participate in any and all mental health services as well as drug treatment. Whatever they say is necessary, then you're going to be ordered to participate in those, whether you think you need it or not. It's now part of your probation. And so all of that is meant to help you to stay on track and do what you need to do so that you can be successful. Also, you're specifically ordered, you cannot have any contact with the victim who is Michaela Stacy. That's also obviously contact in person, but that's communication in any way. You can't send messages, you can't send anything electronically through social media or anything like that. If you do, or you're around her at all, then obviously that's a violation of your probation. You're going to be right back in here. If you violate your probation in these cases, and you are brought back into court, you could be found guilty in each of your cases. And in the first case, you could go to prison for up to 20 years. And in the second, I believe it's a state jail felony, you go to prison for up to 2 years. Do you understand? I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. And then I will sign a dismissal in cause number 23 DCCR 1751 as part of this plea agreement. You need to have a seat here in the courtroom. Probation will call you up to her desk as soon as she's ready to go over your paperwork. Good luck to you, sir. Thank you, Mr. Macon. Was he hired? Already appointed. He was hired. Yeah, just one of ours. No, I don't think it's anything special. Ms. Holmes, you have Roland Guillory sentencing?
Yes, sir.
Good morning.
Good morning.
Good morning, sir. You're Roland Guillory. And this is 24 DCCR 1568. Mr. Guillory was previously in court, entered a plea of guilty to the lesser included offense of a Class A misdemeanor, abandoning or attempt to abandon or endanger a child. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Any additions or corrections?
Just that I've reviewed it with Mr. Guillory. He would like the court to move forward with the plea agreement, and we understand the recommendations of until for parents and classes, and until that is completed, for him to have supervised visits with the child, and also with MHMR.
Yes.
He's tried several times. Their system has been down for quite
It
some
has.
time, but he said they were able to get him scheduled in
Okay, good.
November 11th.
Okay.
Yes, ma'am.
All right.
No additions or corrections, Judge. I do have some concerns, particularly on page 1, under the defendant's version, where he says he doesn't feel like he committed a crime.
I think that's an issue as well. I think with regard to that, probably some of the other issues that hopefully we'll address on the probation, and the fact that it was reduced to a misdemeanor probably covers that, but I did have the same concern. I think I'm going to go ahead and go forward. Are you okay with that, Mr. Coleman? Okay. Mr. Guillory, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That includes participating in the, through Spindletop and whatever the recommendations are through that caseload on probation, completing the parenting class, doing everything you're supposed to, and then not having any, there's no unsupervised contact with any child until further order of the court. So if you go through all those classes and you're well on your way and you're following all the recommendations and following through with Spindletop, there may be a time where probation sends me back something that says, hey, he's doing great, we're ready to do unsupervised, but you're going to have to do everything you're supposed to. If you do everything you're supposed to on this probation, then this is an excellent opportunity because you don't have the conviction on your record. And if you complete the probation, then at the end, the case will actually be dismissed. The other side of that is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the Jefferson County Jail for up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Let's see. Cafeta Jones, I just signed that dismissal. She's free to go. He's free to go, I'm sorry. And then Seneca McDaniels, Ms. Holmes.
Yes, Deshaun Robertson, that's Ashley. This one will be taken care of, this one outside of, down the hall.
Good morning, you're Seneca McDaniels, and this is 24 DCCR 1915. Mr. McDaniels is charged with unlawful possession of a firearm by felon. Go ahead, I'm sorry.
Your Honor, we have an agreement, in which this will be taken care of down the hall as well.
Okay.
So we can get a couple of weeks.
And he's already paid the fine, Judge. I will draw up a forfeiture document. He will sign it in Ms. Holmes' office, and we should take care of it before the next time.
All right, so I'll just do a normal reset. Obviously, if it gets taken care of before that court date, then you can just let him know. Otherwise, make sure you're here on that court date if nothing has been done before then, okay? All right, you're free to go.
Thank you, Judge. It'll be done this week.
Thank you. You've got a Zully Valicia as a sentencing.
Yes, Your Honor. I don't know how you want to proceed on this.
We'll see.
Okay.
Good morning, you're Zully Valicia. And Ms. Valicia, you were previously in court and entered a plea of guilty to burglary of a habitation, a second-degree felony. This is 24 DCCR 1364. The agreement was for a cap of 7 years in prison. I've received the pre-sentence report and reviewed it. Has everyone had an opportunity to review it?
Yes, Your Honor.
Yes, Your Honor, we have.
Any additions or corrections?
I've reviewed the PSI with Zuli. I know that obviously her version, the court has questions about that, and so I would allow her to address that if she does wish to move forward in hopes of obviously us arguing for the probation.
So here's the thing. If you say you didn't do it, you don't get to say I didn't do it, but please give me probation, because then you're not accepting responsibility. So either you did it, what they charged you with, or you didn't. And doing it doesn't mean that you participated fully. And I'm sure Ms. Holmes has explained to you the law of parties in Texas and what that means. But if you say somebody took your car and you weren't even there and you had no idea of it, then that's what juries are for. Because you are about to take the chance, if we go forward, of me sending you to prison for 7 years. Me possibly giving you probation. But I can assure you that you're not going to get any kind of help from me if you get up here and say, well, I didn't really do it, but come on, give me probation. Does that make sense?
Yes, ma'am.
So tell me, if you want to go forward, tell me exactly what you did, what your part of this was.
I was aware of what my car was going to be used for. I didn't participate in the act, but I know.
So you didn't drive your car?
No, I did not. I did not drive it at the scene where it happened.
Mr. Nichols, it appears that the,
If I'm explaining myself, right?
I think what she was trying to say, Your Honor, she wasn't present at the scene of the burglary, but let them use her car and I guess drove them close by. Because we know she was pulled over driving that vehicle on the way.
I mean, there's cameras from Lieutenant Hudson's cameras that confirm that you were driving when you were stopped.
Yes.
With the other guy seated in the
I
front
was in
seat.
town. I was in town when it happened, but I was not at the scene.
So, yeah.
So when did he get in your car?
When they brought it to the crime scene, but I was not at the crime scene. I was.
I'm very confused.
So she drove here to Groves. She drove into town. She was aware of what was going to happen
You weren't aware of it. You drove in to be a part of, you knew. I mean, there's saying I'm aware of whatever. Y'all came into town with.
Can I rephrase myself?
You
Why
probably
would you-
should real quick because
I
hang
was
on.
not- I was
Also,
not at the crime scene.
hold on.
Yes, ma'am.
Because y'all came into town with radio jammers and fully ready with medical mask and face mask and all this stuff to come in from out of town to do what you did here in our town. And so you weren't just riding along and then they said, oh, by the way, sorry you came with us. We're going to do this.
Okay, well, I drove because I'm the one that had the license in case we got pulled over.
Okay.
But I was not at the scene.
So you brought them to do the
Yes, ma'am.
crime.
Yes, ma'am.
It's not that hard to say.
Yes, ma'am. I didn't know how to rephrase myself. I'm sorry.
All right, Ms. Holmes, go ahead with argument.
Yes, Your Honor. She does not have an extensive criminal history. As you can see, there is one prior, looks like a theft of property, which she received 6 months state jail. And then there was a federal case as well back in 2020. Ms. Zuli is currently employed and working. She would like the opportunity to continue that with probation. She does care for family members as well, Your Honor, for a household. As indicated in the PSI, they do have her at a low risk level, which I believe is indicative that she would be successful on probation if given that opportunity. They've also stated in the PSI that they would like her to adhere to any mental health services and comply with those recommendations, as well as the moral recognition therapy program, and to obviously stay off of any premises in which this act was committed. To her credit, they did state that she did express remorse for the actions, and she felt embarrassed for her family and does regret that. Your Honor, it's also stated that based on her statements, history, and circumstances, she does appear remorseful and motivated to make positive changes, which I believe that she can do if given that opportunity on probation. She can get, obviously, up to 10 years, and if the court deems that, we are asking that she be able to do the 10 years probation to give her that opportunity to show that she can be a productive member of society and to possibly, if the court deems necessary, she can have the opportunity at deferred probation to have that time to rehabilitate herself and to hopefully not have another felony conviction on her record.
Mr. Nichols?
Your Honor, I echo the sentiments of Detective Hudson and, Lieutenant Hudson. This wasn't just a crime of opportunity or one-off incident. This was an organized burglary that involved high technology, that involved planning, and targeted this individual's residence. They came in from Houston specifically to burglarize this home, and they did. And I think there's obviously, she flat out lied to the police about being there, driving. She claimed that her car had been reported stolen 2 days before this, even though she was stopped and was on video driving the morning of. So I think the 7 years is appropriate. I'll note for the court, the co-defendant got 10. At least one co-defendant got 10. I'm not sure on the others. But I think 7 years is appropriate, and given the instance in this case.
How'd y'all pick this person?
Sorry.
How did y'all pick this house, this person to come in?
No, like I said, the only reason why I came here was because I had the license. So in case they got pulled over, they didn't have a way to prove their citizens. So I was just like the one that drove into town. I don't know about the.
And if I can, 2 of those individuals have fled the border. They were not legalized, so they probably will never be found. So there were 2 other individuals involved in which she has tried to get contact. So that's the reason why they were involved. She was the driver, but they have since fled the country. They're not coming back. That actually went into the house. There was only one that was caught that received a 10.
Mm-hmm.
So I think that's what she's trying to say is she was driving because they obviously did not have the credentials to do
Right.
that. And we don't know where they are.
So do you know why y'all came to this house?
I have no idea. The only reason that I came into town was because I'm the one that had the license. So in case they got pulled over, they didn't have a way, to prove their legal
How many
status.
other times did they have you drive you to other places?
No, that was the only time I did it, and I regret it. It was crazy.
Your Honor, if I may, I had the co-defendant's case. The victim in this particular instance was a local business owner, owned a donut shop. They also owned a donut shop and forgive me if I'm off on this, the exact city, I think it's somewhere in Humble, or nearby in Humble. That business, their home in that city was also burglarized.
Right.
as well.
So, right, thank you,
I
Mr.
cannot show you I was not involved in any other situation that had to do with them. It was just a one-time thing.
How did you know these guys?
Well, basically, one is my barber. The one that is doing time, he's my barber.
He's your brother? Barber.
Yes.
What about the other two that took
No,
off?
I never knew them.
So where do you live now?
I live in Houston, Texas. Yeah, Houston, Texas.
Do you work?
Yes, ma'am.
Where-
50 hours a week.
For what? For who?
It's integral. It's basically for the state. I get paid $25 an hour.
To do what? I'm sorry?
I don't know how to describe it. It's like solar panels. It's for the state.
Okay.
I have evidence as well.
You have what?
Evidence that I'm working there.
Okay.
Before that, I was working at a car wash, but they offered me more there.
So I don't disagree with Lieutenant Hudson or with Mr. Nichols, because of what happened and the targeted way that this happened. It does appear that the guys were probably in charge of most of this. You made a really, really stupid decision.
Yeah. And I regret it.
Yeah. All right, what I'm inclined to do, because what you're charged with is a second-degree felony. So the range of punishment is up to 20 years if you went to jury, or all right, here's what I'm going to do. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. You're going to be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. So let me explain what that means and why that's good for you, but probably more so for me, and why I'm doing this. So a deferred probation means you don't have this conviction on your record. But what it also means is if you violate any condition of probation, you will be brought back into court, found guilty, so you have the felony conviction, and that cap of 7's gone. I have the full range of punishment between 2 years and up to 20 years. And certain cases, for whatever reason, the fact that this one, I remember it from Mr. Coleman's case, from the co-defendant. I'm likely to remember it. It's never good when I remember things, okay? And so I'm going to order also that you obviously have no contact or communication with any of the co-defendants. If they fled the country, whatever, if they come back, if they try to contact you, you cannot have any contact with them. In fact, I'm ordering if they contact you, that you contact your probation officer and law enforcement and let them know any information that you have about where they are. You will be, I want her on the medium-high caseload to start off with. It means you're going to be reporting more often, making sure you get off on the right track. Because
I work like an hour from my house, so I leave the house at 2:30 and come back home at 2:30 in the morning.
So talk to probation. I want you to work, okay? And so you need to get them documentation of your schedule because there will be a curfew except for employment purposes. You'll be required to report in Harris County, but you're also going to be required to report by mail or online here. So you kind of have double duty. You've got to do it all. If you don't report by mail or online here, it's a violation. If you don't go in person there, it's a violation. If you don't give them proof of where you are when you're supposed to be, it's a violation. If you test positive for any drugs, whatever it is, you're going to be on a high caseload so that I know, at least for some time, that you're doing exactly what you're supposed to be doing. And if you don't, you will be right back in here. Do you understand? All right, I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, she'll call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am.
Thank you.
Mr. Lewis, you have Jaron Crane, 3 cases. Good morning.
Good morning.
Judge, just to refresh the court's recollection, this is the case you allowed us to reset Mr. St. Clair as co-defendant.
Yes.
On Mr. Crane's.
So are we going to go forward? I mean, do we already have a rejection? And
Judge, I got an
well, it's
offer.
Jaron Crane. All right, sir, you're Jaron Crane. And Mr. Crane, you're charged in cause number 23 DCCR 1082 with evading arrest or detention with the use of a vehicle. In cause number 23 DCCR 1406 and 23 DCCR 2233 with aggravated robbery. And what is the announcement?
Judge, we've gotten a new offer, or gotten an offer on Mr. Crane, and I've given it to him and talked to him about it. I was gonna ask for a short reset, maybe like 2 weeks, just so we can talk to his parents. And I think that it'll be resolved at that moment. It won't be.
Okay. Any issue?
No, Judge, that is fine with me. I just want the court to know it's no longer any type of a probation offer that the state is extending based on the nature of where we got last week with Mr. Crane.
Right.
For some reason, that attitude changes. We'll approach the court with that, but I appreciate you letting us hold on that. It is my intention, I want Mr. Crane to know for me, it's my intention to go on his case to trial first and ask that any sentences that can run consecutively, run consecutively.
So, Mr. Crane, I'm going to reset your case a couple of weeks. We're done playing games. All right. So if you were, whatever all happened, if you've changed your mind, it doesn't matter to me. I don't care. But we're not putting your case off for someone else's case anymore. Your case is going to go forward. You have 2 weeks to make up your mind on if you want to accept this plea agreement or not. If you don't, then we'll get your cases set for trial very quickly, and your case will go to trial. And after that, I'm not accepting plea agreements and all of that. So this is where you need to talk to your attorney, family, whatever you need to do. When you come back, I want to know either we're taking a deal that day or you're going to trial. Doesn't matter to me which way, but we're not putting it off anymore. We're not going to say we're going to do this or that and then get your case put off. It's going forward, okay?
And Judge, we can be prepared very quickly. I've already prepared all witnesses in lieu of the other trial.
Okay, thank you. All right, you're free to go. We'll see you in a couple of weeks.
Thank you, Judge.
And then you have Tammy Farrell or Farrell. Mr. Lewis. Good morning, ma'am. Is it Farrell or Farrell?
Farrell.
And will your client waive the formal reading of the indictment?
She does, Judge.
Ms. Farrell, in cause number 23, DCCR 1088, you're charged with, my computer's slowing down, sorry. You're charged with the state jail felony offense of credit or debit card abuse from August 4th of 2021. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would not be a fine. There would be restitution paid in the amount of $15,516, and you would be required to follow all of the other rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Farrell's not competent?
No.
And what about history or waiving the pre-sentence report, since we have that restitution
The
amount?
state's okay with waiving the PSI. I only show 2 misdemeanor convictions, one from a theft from over 20 years ago, another DWI from about a little more than 10 years ago.
All right, so Ms. Farrell, I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and however, I'm going to follow the agreement and defer all proceedings. You are placed on probation for 5 years. You're ordered to pay the restitution in the amount of $15,516 and to follow all of the rules and requirements of probation. If you do that, then this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you could be brought back into court, you could be found guilty, and you could go to the state jail prison for up to 2 years. Do you understand? $15,000 is a lot of money to pay back. 5 years might seem like a while, but it's not. It's very important that you start making payments on that immediately. Even if it's a little bit every month, then it will add up, because what can happen is, let's say you do 4.5 years of probation correctly in every way except paying that restitution, and I make a finding at the end of that probation that you could have paid, then your probation can be revoked and you could still go to the state jail prison for 2 years. Do you understand? It's very important that this gets paid back. I want it to be a priority. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork. She's at that desk right there, so watch for her to call you up. Good luck to you, ma'am.
Thank you, Judge.
Judge, Mr. Rennick, you can approach on.
Yeah. Let's see, on Martin Ward, Mr. Rennick? Hold on, Martin Ward?
I had a quick question for the court. I have an offer that would reduce this to a Class C misdemeanor. My client would like to plead no contest as a civil suit against the complainant. And I didn't want to see if the court would allow that. Because I know that you have hesitancy to allow that contest.
Based on that, do you have any issue? Based on the nature of that, I would be okay with it.
Okay, that's all.
Thank you for asking, though, typically.
I want to make sure.
Okay.
I'm going to get with him, and then I'll have the paperwork done just to make sure.
Okay, I'll hold it while y'all do that paperwork. See, Mr. Lewis, you've got Edward Frank. I'm signing a dismissal in that right now. He's free to go.
Just for the record, reflect on that, that was at the request of, in that meeting of the Mr.
Thank you. Mhm. Is DeAndre Smith here? Mr. Smith, have you heard from Mr. Frank this morning? Okay, but he's coming? Okay. To do what? Okay, well, he doesn't get to do that the day of court. So if you know how to get in touch with him, you can step out and send him a message. We've been trying to call him, but it's important that he does that before today. So he needs to email or check in with the clerk. If you have a number, okay, see what you can find out and come back in and let us know, okay?
Yes, ma'am.
Thank you. I feel like he comes all the time without him. That's so frustrating. Mr. Lewis, you've got Paul McCorvey.
Yes,
Mr. Kimler, can you move your chair out of the way, please? Good morning, you're Paul McCorvey?
Yes, ma'am.
And this is 24 DCCR 1914. Mr. McCorvey is charged with theft of property, and what is the announcement?
Judge, this was the one that it's taken a while to get some things from a probate court, which we did by the last setting.
Right?
It was reset because we was trying to confirm restitution amount with the complainant. She won't talk with us. I think the issue is Mr. Hopfire is going to try to get with the investigator, see if they can confirm an amount. Because basically the restitution was going to resolve the.
Right.
Correct, Judge, and the notes, according to Mr. Hoffbauer, are that based on that probate order, just a very short conversation with the complainant. Now, we have that transcript should get us to a figure that should be able to resolve.
Okay.
And I can make sure that.
If you would, because that's
is
where I
brought
thought we
in.
were last time. And so if you'll get with him and make sure Mr. Hoffpower gets on that quickly so that we don't have another reset based on that, please,
I will,
ma'am.
Judge. I'll bring
Thank
her
you.
in.
All right, stay in touch with Mr. Lewis and he'll let you know when you need to be back. Mr. Kelly, you've got Ashley Sanders.
Yes, Your Honor.
Ashley Sanders. Good morning, you're Ashley Sanders. This is 24 DCCR 1650. We were waiting on audit. Where are we?
Judge, I'm happy to announce, thank you for the court being so lenient with us and resetting this a few times. Mr. Wimberly is actually here this morning with his client, my complainant. They did send me some documentation just right before docket. He's also indicated that his office is this week making notebooks for Mr. Kelly and myself and having everything scanned in. If we may just have one final, now that we have all that information, hopefully we can I can sit down with them, then Mr. Kelly and I can sit down and discuss it and see where we are, and we'll be ready to finally announce next time. But I did want to confirm we do have all that documentation, or
Okay.
it should be to me this week.
All right. Thank you, Mr. Wimberly. All right, so what I'm going to do
And if you want to go ahead and put it on the trial docket, Judge.
No.
I certainly would understand.
Yeah, no, I just want to, let's see,
My only concern when I hear notebook is.
that's what I'm
kinda
thinking as
notebook are we
well.
Talking about,
Yes, sir.
It'll be about that thick.
Okay.
It would all be heavy.
So why don't we do this? When we come back next time, I want it all done and I want an answer. And so what I'm going to do is reset it to the 1st of January. That should be about a 60-day, a little more than that. I want everything hopefully turned over this week. That gives you an opportunity. So unless there's something else that comes up, I want it all gone through in an announcement at the next court date. Okay? All right, you're free to go. Thank you, sir.
Thank you.
Thank you, Mr. Kelly. I don't know how long that is, probably 70, whatever. And to make that note on it, would you, that he was here and just so I don't forget. Have we seen Mr. Gertz off it? I thought I saw him. And then Mr. Kimmler's working on something there. Mr. Rennick's working on his. Mr. Vasquez, were you working on paperwork on yours? Okay, as soon as I'll take care of it in just a minute, as soon as it comes through. Will your client waive the formal reading of the indictment?
She will.
Ms. Clayton, in cause number 25, DCCR 0446, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from March 8th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimmler? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $250 fine.
I'll explain my scribbles, Your Honor.
Oh, that's CCCR. There would be
Yes,
a
there's
dismissal
miscommunication.
in cause number 25 CCCR 1119. And this will run concurrently with 25 CCCR
1053.
1053. Is that your understanding?
There should be another misdemeanor. It was refused. I was refused.
And what are those
The
cases?
dismissed one is resisting arrest, and they're all connected to this, Your Honor.
Mm-hmm.
The dismissal is a resisting arrest. The case to be pled is a DWI.
Okay.
All out of the same criminal episode.
Let me look at something real quick. Oh goodness, I can't see that. If I test you this morning, will you be clean?
Be honest.
Have a seat in the jury box. Have a seat in the jury. Have a seat in the jury box. Let's get you tested. You can tell from those eyes. As bloodshot as they can be. just, yeah. How'd she get here this morning?
Yeah.
How'd she get here this morning?
She's got her sister with her. I don't know who.
Find out
But
for me.
she said it was like 30 days ago, so.
It's not what it looks like.
She was transported by her sister, who's present if the court wants to question her.
Let's see, Mr. Kimler, Ryan Hodge. Good morning, are you Ryan Hodge?
Yes, ma'am.
And Mr. Hodge is charged in cause number 24, DCCR 1167. With the third-degree felony offense of evading arrest or detention with the use of a vehicle. The indictment alleges a prior burglary from 2015, and then also felony of bribing an officer in 2018 and possession of a firearm by a felon in 2018. We had reset that as well, some other stuff as well.
Those are out of state.
Yep. So what that means, though, is for punishment purposes, if Mr. Hodge, if you're found guilty by a jury, you would be considered a habitual offender, which means your minimum punishment, if you go to trial and are found guilty, is 25 years in prison, up to 99 years or life in prison. Do you understand? And we reset this case for you guys to watch the video, and have you had an opportunity to review the video in this case?
I've seen the prior, like, but.
You've seen the video?
I think he's seen it with his prior.
Okay,
previous
so you've
attorney.
seen the video, and have you talked to Mr. Kimler about it? Answer out loud.
Do what, ma'am?
Have you
We've talked about the video.
Yeah, we've talked about it, yes, ma'am.
Okay, and I want to make sure, so I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on count one only, which is just the offense of evading arrest or detention, not those prior offenses, for a cap of 10 years, which means you would leave your punishment up to me. I can give you 10 years, I can give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand what your possible consequences are and what your options are. And do you understand all of that? And so I'm also making the notation here on that plea bargain rejection that I've admonished you as to what the minimum will be if you're found guilty, which is 25 years in prison. You understand? And you want to reject that and have your case set for trial.
He's maintained his innocence.
All right. Then I do want to make sure you understand that after today, I will not accept a plea agreement. I'll get your case set on the trial docket. There won't be a plea. We'll let a jury decide, okay?
So, for any reason, we can look into it further, the facts and the evidence.
Well, that's what a jury's for. And so your attorney has discussed the case with the assistant district attorney. Their position is that it's an evading and they think they can prove that. And that's what we're going to go to trial. Okay? That's what a jury's for. All right? hold on a second.